technical issues sorted out?
Yep.
Okay. Welcome, Attorney.
Morning.
Welcome to the public hearing for the inquiry into budget estimates 2021-2022. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of this land. I would also like to pay respect to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. I welcome Attorney General Mark Speakman and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for portfolios of Attorney General and prevention of domestic and sexual violence. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's proceedings are being broadcast live from the Parliament's website, and a transcript will be placed on the committee's website once it becomes available. In accordance with broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. All committees in budget estimates have a right to all witnesses in budget estimates have a right to procedural fairness, according to procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Attorney General, I remind you and the officers accompanying you that you are free to pass notes and refer directly to your advisors seated at the table behind you. In terms of audibility of the hearing today, we have witnesses in person and via video conference. Can I ask committee members to clearly identify who questions are directed to, and could I ask anyone appearing remotely to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? And finally, could everyone please turn their mobile phones to silent for the duration of the hearing? All witnesses will be sworn prior to giving evidence. Attorney General Speakman, I remind you that you do not need to be sworn, as you have sworn an oath to your office as a Member of Parliament. I also would like to remind the following witnesses that you do not need to be sworn, as you have been sworn at an earlier budget estimates hearing before this committee. Ms. Catherine D'Alia, Acting Secretary, Department of Communities and Justice, and Ms. Anne Campbell, Acting Deputy Secretary, Strategy, Policy and Commissioning, Department of Communities and Justice. For all other witnesses, I ask that you in turn state your full name, position, title and agency, and swear either an oath or an affirmation. The words of both the oath and the affirmation are on the cards on the table in front of you. Please begin with the first witness on my left. Well, that's you, and you've already been sworn, Mr. McKnight.
My name is Paul McKnight. I'm the Deputy Secretary of Law Reform and Legal Services at the Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Thomas, Brendan Thomas, via WebEx.
My name is Brendan Thomas. I'm the Chief Executive Officer of Legal Aid New South Wales, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And Ms. Karen Smith.
Karen Smith, Crown Solicitor. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Is there an extra person I've not got on my list?
Ms. Campbell?
Campbell? Not on my list.
Already sworn.
No, she's already sworn. Then I think that's it. All right. Questions?
Thank you, Mr. Chair. Good morning, Mr. Attorney.
Morning.
Mr. Attorney, this morning you were in the newspaper discussing the flight while on bail of Mustafa Balak.
Yes.
And you expressed some concerns about the bail decision made by the magistrate, noting, of course, that the magistrate's court's very busy. Are you able to tell us about what evidence the magistrate actually had before it from the police in order to reach that particular decision?
So, look, I've read the Sorry, what was the... Just repeat the question.
The question was about the sufficiency of evidence before the court in making that bail determination.
Well, I haven't seen the evidence,
no.
But I have read the transcript. There was, I think, evidence of whatever prior offending the accused had, a proposal that the accused be electronically monitored by a private company, the accused's proposal for surety, which was, I think, $4 million related to, I think, a house at Bayview that was offered as security for that. And submissions were made as to the strength of the prosecution case.
All right. Now, the police were asked some questions on Friday about this matter, and the police minister, I think, or the police commissioner indicated that advice was sought from the Crown Solicitor about the prospects of appealing the bail decision. And I think the evidence on Friday was that the DPP, and that the chances were not strong. Can you explain to us why that might have been the case, why there wouldn't have been, given the amount of money involved, given the resources of the accused?
I haven't seen whatever advice the DPP has given, so I would only be speculating.
Could you take that on notice perhaps and come back to us about that matter? You mentioned both in the article and this morning about the ankle monitoring bracelet being one maintained by a private company. Is that, I mean, pardon my ignorance about this, is this standard practice in New South Wales now for the state to outsource this service?
Yes, sorry, just on it was the Commonwealth DPP that appeared in the Backlog matter. No, my understanding is that where there's electronic monitoring of someone on parole, for example, that's done by corrective services. Electronic monitoring is typically not a bail condition. And typically, rather than prosecutors seeking to impose that condition, it is accused who offer that up and offer to pay for it themselves as a risk mitigation factor and an argument as to why there is not an unacceptable risk if they're given bail. But generally speaking, electronic monitoring is not used for people who are on bail, and typically prosecutors oppose bail being granted on the basis that the risk is mitigated by electronic monitoring.
And in this occasion, was it the defendant who put up this proposal?
That's my understanding.
You could just double check that on notice. Sure. It would be very useful. Next, I'd like to ask you some questions about the prosecution of Mr. Christo Lanka, the producer of the Friendly Geordies YouTube program. Are you familiar with that matter?
I have no involvement in it. I'm only familiar to the extent that I have read and seen newspaper articles and media articles.
That's only because the application to shut it all down failed, so that's good news.
Well, we'll come to that. In that matter, there was an application by the police to suppress Mr. Lanka's the actual presenter of the program, Mr. Jordan Shanks, from continuing to make video product about this. And in looking at the application was put on various bases. One of them was that Mr. Lanka and Mr. Shanks, quote, held a negative agenda against the complainant, Mr. John Barilaro, the Deputy Premier. They've created and aired numerous videos that are derogatory in relation to the complainant's political position. There are quotes in support. Looking at the views on the YouTube channel, quote, just when you thought they couldn't be more corrupt, quote, whoever guessed Australia would openly tolerate crooked cops and crooked politicians. And at the end, there's an assertion that, quote, it's clear from this broadcast that his comments are not designed to be a critique or for entertainment. They're deliberately designed to cause public bias, unquote. So most of the grounds put by the police in favour of this suppression order appeared to be political in nature rather than based on concerns about the administration of justice. Do you, as the first law officer, have concerns about the resources of the state being deployed against journalists like this?
That was a matter for police. When they make those applications, they are independent of my office. I don't think I've had any discussions with any of my colleagues or agencies about the matter, and I don't think it's appropriate for me to comment on the specifics of that matter when it's still before the court.
Sure, well, let's move away from the specifics of that matter. Let's just look at the use of suppression orders to sort of, shut down dissent against the government in this sort of way. Is that the sort of thing that people should be concerned about in a democracy? I mean, leaving aside however this particular matter ends up, and of course in this matter the magistrate, I think, dismissed that, or I think the police withdrew it and then it was dismissed. So it doesn't sound like it had a very strong basis. Should there be a sort of a higher threshold before such applications are made in the future?
I can't answer that question directly without getting into the merits of whatever application was made as to whether the application was or was not on reasonable grounds. I mean, as a general proposition, open justice is a cornerstone of our legal system.
In fact, there's even a Law Reform Commission discussion paper about this.
That's right, and the Law Reform Commission is due to report on that probably by the end of the year. And in any of these matters, you weigh up, on the one hand, the public's interest in open justice, confidence in the justice system when there's transparency and openness, but on the other hand, on occasions there'll be an appropriate basis to suppress evidence if there's a national security issue, if there is as we do with vulnerable witnesses, the identities of vulnerable witnesses, youth offenders. So I can't comment on what is the appropriate balance in that case without descending into the merits of that case, which I don't think it's appropriate to do while the matter's before the court.
Well, okay, the criminal prosecution is before the court, but the court has finalised its decision with relation to the suppression application. Now, on this matter, the police have told this estimates hearing on Friday that they didn't get independent legal advice until after the application was made, but that they did subsequently get advice, I think it was from the Crown Solicitor's Office, and the advice they received was that it was, this is my summation of their evidence, but essentially that it was unmeritorious or unlikely to succeed. Should the police be required in these sorts of matters to get independent legal advice before they make an application to the court, given that this was not about someone's physical safety?
Yep.
This is a prosecution of a journalist making political criticisms of the government and of one of the government's leading figures at the time. So there's no sort of sense of anyone's personal safety at risk.
Look, I know you want to divorce this issue from the criminal prosecution. I think it's difficult though to make a comment on that without potentially trespassing into that. Is it prudent to get independent legal advice? It's always prudent to get independent legal advice if you're taking matters to court. But you know, what legal advice the police obtained here, what that legal advice said, I don't know.
I understand that, Mr. Attorney. I guess what I'm saying is, as a matter of policy, before the police do this kind of thing, shouldn't they be required to get independent advice so that the court's time is not taken up with applications like this by the state?
Well, look, they're probably, that is probably a question better directed at the Police Minister or the Police Commissioner, and you may well have done that on Friday, about appropriate use of police resources. But I don't think I can comment on that without, again, descending into the detail of the case.
All right. Now, this matter flowed from the use of the Fixated Persons Unit, and we've investigated this over a couple of estimates, and it seems that since 2017, it's investigated over 214 individuals. About half of those matters appear to be political referrals by ministers and MPs. And of course, a number of individuals have ultimately been charged. Looking at this matter, though, although it's still before the courts, you've got a university student who's a producer of a satirical news program being prosecuted on the basis, as I understand it from Friday, that somehow his approaching Mr. Barilaro for comment, which is all on video, somehow harmed Mr. Barilaro's psychological well-being. Now, I can't see what Mr. Lanka did that's different to what The Chase has done or what, news programs have done, chasing people down the road with microphones shoved in their face. Whatever the desirability of that, what Mr. Lanka has done doesn't seem to be that much different. Yet the police have felt this was so serious as to warrant a prosecution.
For intimidation.
For intimidation and harassment. A sort of 65-kilo university students apparently meant to have intimidated Mr. Barilaro by asking him for comment.
110 kilo, Mr.
I acknowledge that. So given what appears to be the unlikelihood of a successful outcome in that matter by the police. Nevertheless, that's what's before the courts. You're the Minister for the Prevention of Domestic Violence. Many women fleeing domestic violence get intimidated, stalked, harassed by their current or former intimate partner. It doesn't seem very many of these fixated persons unit matters seem to have been deployed to assist them. So as the relevant minister, what level of assurance can you give people fleeing DV to try that the resources of the state will actually give them the same protection that Mr Barilaro seems to be receiving?
Well, again, I can't comment on the Barilaro Friendly Geordies case and the merits or otherwise of the police prosecution, because that matters before the court. I think it's probably a long bow to draw between that case and domestic violence complainants. Domestic violence complaints make up about 40% of the, as a rough ballpark figure, of the work of general duties officers in the New South Wales Police Force. Every police command, police district has a domestic violence liaison officer. Every region has special, I'll paraphrase, a special force or a special unit to go after high-risk offenders. So more resources than ever of the New South Wales Police Force have been devoted to combating domestic violence than ever before. Large campaigns with ADVO compliance checks. And you'll see that the numbers of those compliance checks have gone up much more rapidly than domestic violence prosecutions. Breach ADVO prosecutions have gone up much more rapidly than the underlying rate of domestic violence prosecutions. So there's, I think, plenty of evidence that the police are taking this very seriously. Can they do better? No doubt they can. The Auditor General at the moment is looking at police responses to domestic violence, and the government will certainly be interested in what the Auditor General has to say on that topic.
So going forward, do you think that the same level of resourcing will be provided to victims of DV, that where they are being harassed and intimidated by their former partners, that they will get this kind of the same level of protection?
Well, one of the offences for which prosecutions have increased significantly is stalking and intimidation, which I think is fairly substantial evidence that police are actively prosecuting domestic violence. In fact, others would criticise them for discretionary policing that goes too far. Others would say the fact that stalking and intimidation offences have gone up when others, recorded offences have gone up significantly when others haven't, is evidence of policing practice rather than underlying changes in the rate of domestic violence. So I am confident that police are more and more prosecuting and protecting victim survivors. But no doubt there are matters that can be improved, procedures that can be improved, and that's why I've got an Auditor General inquiry at the moment.
Okay. As the first law officer, though, are you concerned that the resources of the state are being deployed against a journalist who has been criticising the government on the basis of its political agenda?
Well, that sort of implicit in that question is a supposition that the case against the journalist is unmeritorious, and that's a matter before the court.
Okay. So once this matter's resolved, we may have to return to this for a longer discussion then. Attorney, in relation to the ICE inquiry, there has been it's been something like 21 months since the final report has been provided. Why is it taking your government so long to release its final response to that inquiry?
Well, I hope I'll be able to say good things come to those who wait. I think a final response is imminent. It's an incredibly important area of the law and of, probably more importantly, of health. There are over 100 recommendations. There has been vigorous analysis within government of those recommendations, and I would hope that we'll be in a position shortly to release our response.
Can you indicate any general time frame for the government on releasing its response?
I can't give you a precise date, but I could say sooner rather than later, and I would be disappointed if it were not this year.
Okay. What do you say to stakeholders that have said that this has just taken too long for the government to come forward with its response?
I understand and I feel their angst, but hopefully we will get a good landing on health and criminal justice outcomes that will be worth the wait.
There's been recent media reports that the government is considering legislation to expand the police diversion program to include heroin and ice in line with the recommendations of the ICE inquiry. Will the government be including all drugs in such a program?
Look, that's a matter for cabinet. I can't preempt that. But I've made, I suppose, my general position pretty clear that this is ultimately a health issue. Yes, the criminal justice system has a role to play, particularly in dealing with importers and traffickers. But ultimately, locking someone up and throwing away the key will not solve their addiction problem. What form diversion will take, pre-court, post-court, court diversion, permutations and combinations, they're matters for cabinet, and I can't preempt what cabinet may decide or what my discussions will be and have been with cabinet colleagues.
I hope is Labor won't be totally unmeritorious and smash any minor movement in this place, as they have done every other time.
Well, I think I'm asking the questions, David. You'll get
That's
your
the
chance.
hope, that the Labor doesn't politicise it and tear down reforms.
On that happy note,
That's the history of it.
Minister, in response, in its interim response to the Special Commission of Inquiry, the government announced that it would reject several of the final report's recommendations. And one of those recommendations was that the New South Wales government should establish a statewide clinically supervised substance testing education information service with various branches. Can you explain to the committee the reasoning behind the rejection of those recommendations?
I think the rationale for rejecting pill testing is the signal that it may send of normalising drug use. There is another recommendation there, though, about broader analysis of substances that are seized, and the government's response to that will be part of the final response.
One of the recommendations that was ruled out also was that the police force should cease the use of drug detection dogs at music festivals, and that was, I think, based on the idea that people carrying drugs, young people carrying drugs, would panic and ingest them rather than sort of ditching them in other ways. Can you explain to the committee again the rationale in rejecting that?
Well, that's one rationale that's offered. I think another rationale the police contend for is that use of sniffer dogs is an effective form of drug detection.
Despite being wrong 2/3 of the time.
Well, I'll take that on notice.
Well, how can you call that effective?
Attorney, the current cannabis cautioning scheme, which gives discretion to police to caution for possession of cannabis, appears to have led to a disproportionate number of Indigenous First Nations people being issued with fines. For example, between 2013 and 2017, I think 40% of people issued with cautions were non-Indigenous, and only 11% of First Nations people were issued with cautions. There seems to have been a disproportionate outcome in the cautioning scheme. What are you doing to address that going forward?
I think, just to be clear, the cautioning scheme does not include imposition of fines. Mm-hmm. There are two formal cautions. Look, on one view, I would have thought it's a positive thing if a higher than population proportion number of Indigenous people are being diverted through a cautioning scheme. So they're not being criminalised. Mm-hmm. They're not getting a criminal record. They're not being hauled before the courts, but they are given on the first and second caution information about drug services. But they are not subject to any criminal sanction if they receive a formal caution.
Attorney, I'll come back to that.
Did you want to finish that?
No, I'll come back to it. It's all good. Yep.
Attorney, nice to see you. Ms. Delia and the other witnesses, thank you for coming today. Ms. Smith, did you...
That's the only nice thing you'll say today.
That's the only nice thing you would say.
It's all downhill.
Paquette, that's a delightful tie. Yeah. Ms Smith, did you provide advice to the police, or did your office provide advice to the police about their application for a suppression order in the Jordan Shanks matter?
I don't think I can comment on advice I've provided to my clients.
Well, I'm asking you if you provided advice, not the content of the advice.
Yeah. I've certainly been involved in that matter, but if you wanted to ask questions about the advice, I would ask you to ask that of my clients.
Yeah, well, I'm asking when you were asked to provide the advice to your client. Your client in that case being the New South Wales Police Force, Ms Smith.
Yeah, I'd ask you to ask questions about any advice I've provided to any clients, to the clients themselves, including matters relating to timing and content or anything to do with it.
Well, Ms Smith, I'm asking you. So, when did you provide advice? Let me finish. When did you provide advice first provide advice to the New South Wales Police regarding the suppression order that they were seeking in respect of Jordan Shanks?
As a legal practitioner, I'm bound by the legal professional rules. I'm bound by a duty of confidentiality and a duty to my client, so I can't answer questions about any advice I've provided to any client.
Ms Smith, can you shed any light on whether or not the timeframe the New South Wales Police have asserted, being that they first sought advice from you after they commenced proceedings, the suppression order proceedings, can you shed any light on whether or not that evidence from the New South Wales Police is accurate?
I am not familiar with the evidence that the police gave on Friday, but in any event, I can't comment on anything to do with advice I've provided. That's a matter for my client.
Attorney, have you satisfied yourself whether or not the police's position, which was that they didn't seek any legal advice until after the proceedings, the suppression order application had been filed, given that that advice was sought from your own department, have you satisfied yourself as to whether or not that police position is accurate?
Well, I haven't been asked to. I've had no involvement in the case. And when you say advice was sought from my department, I mean, the Crown Solicitor operates independently of me and of public servants like Ms Delia and Mr McKnight. So as a practical matter, Ms Smith is not someone who reports to me or is part of my department.
Well, I'm going to ask you now, is the police position that they first sought advice after commencing the suppression order proceedings, first sought advice from Crown Solicitors after that, is that accurate?
I don't know.
Will you make inquiries?
I will make inquiries.
Attorney, did you have any role, or did your department have any role in the application brought by the Department of Premier and Cabinet to have the bulk of last week's ICAC hearings and this week's ICAC hearings, to the extent they relate to any Cabinet in confidence documents or discussion about Cabinet in confidence documents, as private hearings in camera? Did you have any role in that?
Did I have any role?
Yes.
No.
Were you aware of the application being made by the Department of Premier and Cabinet the week before last week ICAC's hearing started?
No.
When did you first become aware that the Department of Premier and Cabinet had sought to have the bulk of last week's ICAC hearings in private and not available to the public?
That's loaded, David. That's not consistent, actually, with how this thing is run.
Well, if that be the case, until an application was made by Ms Berejiklian's barrister on Friday morning, I was unaware of any application to keep any part of last week's evidence confidential, private, suppressed, however you want to put it.
Were you aware of the submission made by the Department of Premier and Cabinet on or before the 14th of October of last week, of this year, which is referenced in the hearing, in the judgment/report of Commissioner McColl? Were you aware of the submission put by the Department of Premier and Cabinet that all matters in relation to cabinet in confidence documents and discussion about cabinet in confidence documents should be in private hearings. Were you aware that the Department of Premier and Cabinet had made
To the
that
best of my recollection, no.
And are you aware that this was an application not made by former Premier Gladys Berejiklian, but in actual fact by the New South Wales Government through the Department of Premier and Cabinet?
To the best of my recollection, no.
And so are you saying now is the first time you become aware of that?
To the best of my recollection, yes.
Is Mr Maguire's legal costs before ICAC still being met by the people of New South Wales?
Yes. I'll qualify that. I don't know whether all his legal costs are being met. I don't know whether there is a gap between that part that the state is funding on the one hand and what he might be personally incurring on the other hand.
Ms Delia, do you know how much has been paid to date?
I would have to take that on notice.
Or, do you know what the cap is for any particular day for the legal costs?
Give me a moment. I can give you sort of a general response. So where approved, applications under Section 52 of the ICAC Act are generally approved for assistance by either a solicitor or junior counsel at the following prescribed rates: $180 per hour plus GST for preparatory attendance to a maximum of 3 hours, and $240 per hour plus GST to a maximum of $1,440 plus GST for attendance before ICAC.
Attorney, the Premier's memorandum on ex gratia legal assistance in relation to ministers requires that before an application can be successful, that the incident which gives rise to the proceedings must relate to the minister's official functions. Are you aware of that as the Premier's memorandum?
Without refreshing my memory with the document in front of me, that's my general understanding.
Yeah. Ms Delia, are you aware of the Premier's memorandum?
Yes.
Yep. Can I ask, in what way does Mr Maguire's conduct, which is now been repeatedly reviewed by ICAC, in what way did that relate to his parliamentary secretary functions or any of his official functions as a member for Parliament? How on earth is Mr Maguire having his legal costs paid by the people of New South Wales?
My understanding is his legal costs are not being paid under the Premier's memorandum. He's been granted assistance under Section 52 of the ICAC Act as a witness in a public inquiry.
Is that what are the criteria before a witness? What are the criteria that need to be satisfied before a witness, such as Mr Maguire, has their legal costs paid by the people of New South Wales under Section 52 of the ICAC Act?
So under Section 52 of that Act, the Attorney-General or his or her delegate, in this case it was my delegate, may approve the provision of legal or financial assistance to the applicant if of the opinion that this is appropriate, having regard to any one or more of the following: the prospect of hardship to the witness if assistance is declined, the significance of the evidence that the witness is giving or appears likely to give, and any other matter relating to the public interest.
In terms of the public interest, it's now abundantly clear that the conduct for which Mr Maguire is being held to account was conduct that had no legitimate connection with his work as a parliamentary secretary, no legitimate connection with his work as a member of Parliament. How is it that he's still having his legal costs paid then?
Well, the decision to grant him legal assistance was not one made by me, but under delegation by the then Secretary of the Department. In all
That
these,
Mr. Coates-Trotter?
Mr. Coates-Trotter.
Gave evidence on the last occasion.
In all these cases, given the potential controversy about granting legal assistance to any current or former politician, it's been my practice to keep well away or completely away from the decision making and
Very wise, Attorney. Very
delegate it
wise.
either to the Solicitor General or the Secretary of the Department, and I have confidence in each of those that they will make an appropriate decision, be it an application under the Premier's Memorandum or an application under Section 52.
But, Attorney, when was that decision made by Mr. Coates-Trotter?
I'd have to...
I think Mr. McKnight might be able to assist.
We would have to take that on notice. I think questions of timing in relation to Mr Maguire were taken on notice last time, and the committee was provided with some information, but I'd need to go back.
Sometime in 2018, though, was when the application was
That
approved.
information in front of me.
Attorney, now we have so much more information about Mr. Maguire's behaviour, and I use behaviour in as neutral a term as I possibly can. Will you ask the delegate to review whether it continues to be in the public interest to have Mr. Maguire's legal costs paid for by the people of New South Wales?
Look, I think it's very important that in these cases before ICAC, there is no political interference one way or another with the provision of legal assistance. I intend to keep at arm's length from that.
I'm asking if you'll seek a review.
Yeah, well, I've just said I do not intend to involve myself in any decisions about legal assistance to any witness to ICAC. It's important that politicians or that ministers keep well away from those decisions. It is typically a condition of legal assistance that if there is a criminal finding against the witness based on the allegations before ICAC, there is a clawback of legal assistance that has been given.
Ernie, the problem with that is, whatever the view of the public interest may have been when the initial grant was made, we now know so much more about this man's behaviour and this man's behaviour as a Member of Parliament and as a Parliamentary Secretary, that any fair consideration of the public interest now would likely come to a very different result than what happened in 2018. And are you telling me there's no process to review the continued payment of Mr Maguire's legal costs by the people of New South Wales, notwithstanding what happens in ICAC?
Look, the public interest is in witnesses getting legal advice rather than the public interest in his actions. It's not appropriate for me to change an arm's length practice of leaving these decisions to the Secretary or the Solicitor General acting in the public interest rather than me putting a political lens on the matter.
Well, if that's the test, that the only issue for public interest is that there's a public interest in people getting legal representation, well, then you may as well not have a public interest test at all, because every time that will come up with a yes. You're not seriously telling me that's the public interest test applied, are you, Attorney?
Well, the test in Section 52 is very broad. It's any matter relating to the public interest. And as I say, I don't think it's appropriate that I, as a minister and a politician, in any way immerse myself in the arm's length decisions of the Secretary or the Solicitor General about legal assistance to witnesses in ICAC.
Well, Attorney, does that mean you're recanting from your earlier evidence that the public interest is simply in ensuring that someone gets legal representation? Do you accept that if that is the test and that's what your delegates have been applying, well, then they're failing to actually to actually review the whole public interest?
I haven't been telling them how they should apply a public interest test. I have left it to the Solicitor General, the second law officer, or in the case of Mr Maguire, the Secretary, to apply the language of Section 52 of the ICAC Act.
Well,
the principle that there is a public interest in witnesses having legal advice. There is obviously not a public interest in people defrauding the state or misconducting themselves in public office, but there is a public interest in witnesses having legal assistance when they give evidence before ICAC, and it's a matter, as a general proposition, and it's a matter for the Secretary in this case to have decided whether that public interest justified giving Mr Maguire legal assistance.
Well, Attorney, the reason I'm pressing you on this is because you say it's not your decision, but I couldn't help but note that the advice you got from Mr McKnight when I was asking you about it earlier was that the public interest was limited to ensuring somebody had legal representation. And let me finish. If that is the basis upon which your delegates are reviewing the public interest, well, the answer will be people like Mr Maguire get it every single time. And that appears to me to be a gross misreading of Section 52 of the ICAC Act.
Well, I would agree that Section 52, the concept there of public interest is broad, but a principal public interest is in witnesses who are giving significant evidence having legal assistance. And Mr McKnight, to my left, I don't think had any involvement in... No, he was not involved in the decision to give legal assistance to Mr Maguire. That was Mr Coates-Trotter.
So to be clear, notwithstanding how much additional information we now know about Mr Maguire's behaviour, you won't be seeking a review of his legal costs, of his legal assistance?
Look, you and any member of the public are free to make a submission that his legal assistance should be discontinued, but I don't think it's appropriate for me as a minister/politician to be immersing myself in decisions that are made by the Secretary or the Solicitor General at arm's length about these contentious matters.
Mr McKnight, is there any administrative process that would bring up a review of a decision to provide someone like Mr Maguire with their legal costs being paid for by the people of New South Wales when there's been a material change or material additional evidence? Is there any administrative process, or is it once the ship sets sail, it just people of New South Wales just keep paying?
I'm not aware of any review happening in the past, which is not to say there isn't, that isn't possible. I'd have to take that on notice. Couple of things that happen once legal assistance is granted that are important, I think, to note. One is the clawback provision that the Attorney General alluded to. So when legal assistance is granted to any witness in ICAC, they must sign an agreement that if they are later convicted of an indictable offence, that they pay back those legal costs. And the other issue is, I guess, that we are careful about is when the bills come in, we moderate them carefully to ensure that the costs incurred are reasonably attributable to the ICAC inquiries and that they are within the rates agreed.
But if there's a finding of corrupt conduct, that has no impact. Mr Maguire will keep the assistance even with a finding of corrupt conduct against him, unless it eventuates at some point in an indictable offence.
That's right. The clawback provisions relate to later conviction in an indictable offence.
And, all right, thank you. Attorney, when will New South Wales move on raising the age of criminal responsibility? When are we likely to get a decision from you?
Well, that has been the subject of discussion at the former Council of Attorneys General, now the Meeting of Attorneys General. The ACT has announced it's going to go to 14. The Northern Territory, prior to CAG/MAG's discussions, had indicated an intention to go to 12 as a result of a Royal Commission recommendation. Queensland indicated before the last election it did not intend to move. New South Wales is still considering its position about whether to move, and if so, to what age and in what circumstances. I am hopeful that things will come to a head with the interjurisdictional discussions sooner rather than later and either reach an agreement, or if an agreement can't be reached, agree that that process comes to an end and each jurisdiction makes its own decision.
And back to the opposition.
Thank you. Mr Attorney, in relation to the 2019 LEC report on the Child Protection Register maintained under the Child Protection Offenders Registration Act, the Commission found in Operation Tusket that since 2001 the police force had made over 700 errors in the application of the legislation. Some of the consequences were that 96 people not being on the register when they should have been, 43 cases where people were registered when they shouldn't have been, more than 600 cases where offenders' reporting periods were too long or too short, 13 wrongful convictions, and I think I'm right in saying the police have written to 277 people subject to, quote, unlawful or unjust actions, unquote, because of errors with the register. Now, recommendation 3 from Operation Tusket was that the Attorney-General urgently refer the legislation to the Law Reform Commission for comprehensive review to be completed within 6 months. That was in 2019. 19 months later, the LEC did a supplementary Operation Tusket report confirming that recommendation 3 had not been actioned and stated, and I quote, unless problems with the statutory framework set out in the Operation Tusket final report are adequately addressed through the law reform process, it is inevitable that errors will continue to be made in the administration of the register, unquote. Attorney, yesterday was the 2nd anniversary since the first Operation Tusket report was handed down. Have you referred this issue to the Law Reform Commission or otherwise actioned that recommendation?
No, I've not referred it, and I don't currently intend to refer it to the Law Reform Commission. Since that report and the supplementary report, there's been a great deal of work by police. I think and speaking with heads of jurisdiction, or a head of jurisdiction as well, on possible law reform, and that work is still underway.
Yes, well, we did ask the Minister for Police about this on Friday, and he was completely unforthcoming in terms of any transparency about timeframes. Now, I've reviewed some of the media reports. It seems that the police agree that there are significant problems with the legislation, but it also seems that it was the police were instrumental in blocking you referring it to the Law Reform Commission. Is that correct?
I don't think that's correct.
Well, you would know, Mr Attorney, wouldn't you?
No, I'm just trying to think of how you would characterise what happened. I think the police were keen to develop their own proposal. I don't regard that as blocking me referring it to the Law Reform Commission, but rather me giving them the opportunity to develop a proposal. The law reform has been busy with a number of other matters, consent law reform, digital assets, open justice, and it didn't seem to me to be the best use of their resources to refer this matter to the Law Reform Commission when the police appear to be confident that they can come up with their own proposal.
Well, it's 2 years on. Everyone seems to agree there are problems with the legislation. I think the legislation's already been patched up some 41 times. What is the reasonable time frame within which the community might expect the government to take action?
Well, look, sooner rather than later, but I can't put a precise date on it at the moment.
Should we expect legislation this year?
I would not expect legislation this year, no.
Should we expect legislation sometime in the balance of this parliament?
I'd be disappointed if there were not such legislation.
So we might expect something next year, perhaps?
I can't give you an assurance, but it is certainly my hope that there'll be legislation next year.
Given just what we know of the impact of these errors, you know, miscarriages of justice, people being wrongfully added to the register when they shouldn't have been, and equally concerning for the community, people who should be on the register not, is there no sense of urgency gripping the government about this matter?
Well, there is certainly a sense of the need to do this promptly, and for the reasons you've identified, but we've got to land in the right place.
I understand that, but okay, well, I'll ask this question. So the police are working away on this. Is your agency or department involved in this at all, given its expertise in law reform?
Yes.
Okay. And are you confident that a sensible landing will be reached?
I'm hopeful that one will be, yes.
But again, you just can't give us any sort of sense of when that might be.
I can't give you a precise date. I'm not trying to be unhelpful.
No, I'm just trying to find out when we might see some action.
I can't see it happening this side of Christmas, but I'd be disappointed if we didn't do something next year.
Okay. Well, I guess hopefully before the 3rd anniversary rolls around, we might see some action, would you say?
I would expect so.
Okay, well, that's good. Now, Attorney, one of the Premier's priority is in relation to domestic violence, to reduce the number of domestic violence reoffenders by 25% by 2023. How are we tracking towards that Premier's priority? Where are we up to?
That is a very challenging priority. Numbers are not tracking down. Part of the problem is, like sexual assault, domestic and family violence is a notoriously underrated crime. So if there is more police activity of the kind I adverted to a bit earlier this morning with prosecuting ADVO breaches, increasing stalking and intimidation offences, more aggressive policing, that is going to drive up the number of domestic violence offences and reoffences without necessarily indicating an increase in the overall rate of reoffending. So part of the problem with that metric is if you have a higher volume of reported reoffenders, it is likely to reflect increased policing and increased detection rather than increased offending. It's difficult to separate to what extent any numbers or any trends reflect underlying offending and changes in reporting and policing. A couple of proxies might be the rate of domestic violence homicide, which has been stable over 2 years and 5 years, because that can't be hidden, that's going to be reported. Mm-hmm. The rate of domestic violence causing grievous bodily harm, because it's fairly hard not to report that. If victim survivors go to hospital, for example, that's been stable over 2 or 5 years. But the numbers, the reported numbers of domestic violence reoffenders have not gone down in the way we hoped. But that probably reflects police doing their job in picking up ADVO breaches, in aggressive policing and surveillance of known high-risk offenders.
Yes, you mentioned that reoffending rates have increased. I think they've gone up 3.9% from the baseline year. I think it's 2015.
Are you referring to reoffending or offending?
Yeah, sorry, reoffending. Have you had any discussions with the new Premier about changing the reduction target in the light of this?
No, I haven't. No, I haven't. So an alternative target would be victimisation. Mm-hmm. And I know the agency has had discussions with the Australian Bureau of Statistics about this. As I understand it, the problem is so it does a personal safety survey every few years. As I understand it, though, it may be that the numbers or the data it collects are not sufficiently large to be able to robustly analyse that. So that's something that I think DCJ, Department of Communities and Justice, are having discussions about with the Australian Bureau of Statistics to try to have a larger database or a more granular database that would allow us to look at that.
Mr Attorney, until 2019, I think the target date for a reduction of 25% of the numbers of in reoffending was 2021, yep. But in 2019 that was pushed back a couple of years, presumably because of the difficulties that you've adverted to.
No, that's not the reason. Okay. My understanding is it was pushed back so that programs in custodial settings and non-custodial settings that have been started by 2023, you are looking at whether cohorts that underwent those programs have had a reduction in recorded reoffending, whereas the 2021, you're comparing that with a baseline that had cohorts that hadn't undergone those men's behaviour change programs, the sorts of programs we're running in prisons with, we started programs for those who are on remand for a short period, high intensity units, equips and so on. So that was so that we were measuring the success of programs that hadn't started with the baseline that would be used for a 2019 cut-off.
Okay, well, now that we've had a bit more experience of these programs, how are they tracking?
So each of the programs has been or will be evaluated by Boxar to see whether they reduce reoffending. But as I've said, the problem at the macro level is that increased police activity in going after domestic violence offenders has meant an increased recording of reoffending, even though if you take domestic violence homicide and domestic violence causing grievous bodily harm as a proxy for the best proxy we've got for underlying rates, those rates have been stable.
Okay, well, in relation to, you mentioned a number of the programs. That was, they include men's behaviour change programs such as Engage, What's Your Plan, Reinvest, Equips. Are they all still underway?
They're all still underway. So What's Your Plan has been recently evaluated by Boxar, and unfortunately that didn't show any difference in reoffending. So that's one program for which we had high hopes, but they haven't come to fruition. So we've got to review that program to decide whether to continue it or whether it can be modified in some way that may have better prospects of success. Reinvest is still underway. We should have the results of that by June 2022. Equips is also underway as well.
How many domestic violence perpetrators are participating in the Engage program?
I can't give you that number offhand. I'll take that on notice.
No, that's fine. You may have already covered this, but was the evaluation of Engage, did it actually start in February 2020 as it was intended to?
I'll have to take that on notice.
Ms. D'Elia, assist us.
I don't have the information, but Anne Campbell may.
Ms. Campbell?
No, I don't have that detail, but we, again, can take it on notice.
Okay. Do you know how many men are participating in men's behaviour change programs overall?
Is that to me or Ms Campbell? Or either of us?
I think the default is we start with the Minister, and if the Minister can't take it, then he or she may.
I don't know the number offhand. Ms Campbell?
I'm just checking my notes. No, I need to take that on notice.
Okay. Has a review of men's behaviour change programs been undertaken?
So my understanding is Boxar is undertaking a review of those, of that. Ms Campbell might be able to elaborate further.
To take that one on notice, Attorney.
Okay. Look, I'm going to ask a series of questions and they may all be taken on notice. How many perpetrators are participating in Equips?
So in 2021, there were 2,544 domestic violence offenders who participated in Equips while in custody. Mm-hmm. There were 1,129 DV offenders who participated in Equips in the community. There were, and 62 programs were conducted in correctional centres, and 63 programs were conducted in the community.
And has a review of the Equips program been undertaken?
I'll have to take that on notice, but if it hasn't been completed, it's certainly, my understanding is every one of these programs has been or is being reviewed.
Okay. Well, perhaps
from a among other things, from the question of do they reduce reoffending?
Yes. Well, rather than, perhaps you could provide on notice list of all the programs, whether they're being reviewed, where the reviews
Certainly.
are up to, and if they have been reviewed, what the review found.
Certainly.
That would be good. Now, in mid-August, I think it was, Domestic Violence New South Wales released their report on the impact of the 2021 Greater Sydney COVID lockdown on specialist domestic violence and family violence services after surveying the people they work for. 73% of services said they faced increased demand. 84% of services said there was an increase in the complexity of the situations for clients who had been referred. And of the 33 services operating wait lists, there had been an increase in the length of the wait list of almost half of the services, which is just under 50%. These are pretty alarming statistics. What is the government doing to tackle this sort of surge in demand?
Sure. So our apart from spending that is earmarked as domestic violence spending, there are hundreds of millions of dollars that are spent on domestic violence in the ordinary operations of the police force, in education, in emergency departments in hospitals. Our budget this year on domestic violence earmark spending is up 27% on last year. That's apart from last week or the week before's announcement about $484 million for primarily for specialist housing. So last year there were 3 tranches of New South Wales and Commonwealth money to top up frontline services. Although, as I say, the underlying rates of reported domestic violence in police statistics and box-star statistics suggests stability, most frontline services reported increased demand, both in volume and in complexity of needs. So in the first lockdown, around about May last year, there was $21 million of a first tranche that topped up existing service providers. There was another tranche of about $12 million in Commonwealth money that the state government distributed. There was a grant application process for service providers, and then a third tranche, half of which went to safe rooms and AVL upgrades in courts, and roughly the other half for infrastructure for frontline services. In our 21-22 budget, we announced another $60 million over 2 years for frontline services. That's $30 million this financial year, $30 million the following financial year. That's complemented by $80 million in Commonwealth money, $40 million per year. And on top of that, we've announced around $27 million to expand staying home, leaving violence right across the state. So at the moment, staying home, leaving violence is only available in 33 locations in New South Wales. So there's a bit of a postcode lottery when it comes to being able to avail oneself of that service. That's a service which, rather than finding crisis accommodation for women and their children fleeing domestic violence, keeps women in their homes in secure circumstances. So that money will go to having that service available right across New South Wales. It is not only a kind of quasi-accommodation service, keeping women and children in their home, but also wraparound services as well, casework and counselling. The money I spoke about, the $140 million, 80 from the Commonwealth and 60 from the state, has not yet been allocated. We've been consulting stakeholders and sector, including Domestic Violence New South Wales, as to how that money might be best spent. And I would hope to be able to announce a tranche of that funding in the very near future.
How very near? Christmas beforehand?
Oh, but certainly before Christmas, yeah.
Okay.
Yeah. I'd be hoping this month.
Okay. So when you go through the figures, it seems, as you say, that domestic violence is increasing in many areas. For example, I think in the Sutherland Shire, it's increasing by 9.3% annually, I think, over a 5-year period. And you look at other parts of the state, you can see many places with very similar experiences, either on a 2-year or a 5-year basis, increasing very, very considerably. What sort of holistic responses? I mean, apart from rolling out more of these existing programs, what sort of root and branch policies are you considering?
Can I just say something about those statistics? You will get significant regional variations. There'll be some regions showing a significant increase in reported domestic violence offences of the kind you've described, but the state average is fairly stable. It's sort of inherently unlikely that in a broad police district, domestic violence has suddenly gone up rapidly where it hasn't in other areas. So that tends to suggest it reflects differences in the type and level of police activity. So where you've got a very large increase in one area but not in other areas, it suggests that there has been greater policing of apprehended domestic violence orders, stalk and intimidation and so on. So that's a response to the use of those statistics. On the question of a holistic response, there is a national plan that all Australian jurisdictions are participating in that's due for release in 2022. We'll be having a 5-year state strategy for domestic and family violence and one for sexual violence as well, that we want to make sure it complements and integrates into that national plan. The Women's Safety Summit was held 2 months ago now, virtually, with a lot of important feedback from that. But it's clear in terms of what are we doing holistically. You have to combat domestic violence on many fronts. You have to have primary prevention programs in schools and out of schools that change entrenched attitudes to women. You have to have a part of that primary prevention, the economic emancipation of women so that they are free to leave violent environments if that's what they need to do. They're not economically trapped. You need early intervention programs. You also need accommodation. You need wraparound services. You need somewhere for women and children and men fleeing domestic violence to go to. Casework, counselling, you need all of that. You need to deal with men's behaviour change programs and holding perpetrators to account. So it's a complex problem. It's a problem that crosses many portfolios in government, and you certainly need that holistic approach to tackle it.
I'll come back to that.
Okay. I'll now hand over to my colleague, Ms. Abigail Boyd.
Thank you. And good morning. Lovely to see you. Just picking up on that, I guess the reoffending rates increasing and the complexity when it comes to how you capture that and the different impacts of, presumably good policing might result in more reoffending being caught. So I've often thought that was a bit of a weird target to have. Has there been any thought given to a target for this government of something like a 0 deaths, like we have for roads, where we're actually looking at the numbers of victim survivors and judging how well we're doing by how many women are dying?
No, that's an interesting thought. I think you would want to do more than that. It's not just the number of women dying who are a tiny but sadly incredibly tragic proportion of overall domestic victim survivors. I think you'd want probably a broader metric than that.
So even, I guess, if we flip the current target on its head and talk about the sort of a target rate for women not facing a second incident, so being reoffended against, if you like, would that perhaps capture the more complex nature of domestic violence than the current target?
That might, I'm told, and I'll invite Ms Campbell or Mr McKnight to correct me or add to what I say, but my understanding is to get the data to do that would be an exercise that would cost several $1 million a year in data collection. Now, that some may well argue that's a worthwhile exercise, but that's That's the challenge.
So I asked during the Premier's estimates, the one where we were just with the officials in September, I asked about the reoffending rate and asked for more data on that. And I was specifically interested in how many of those reoffending were reoffending against the same victims. They were able to provide me with that, and it's well over the majority, from my recollection, of reoffenders are reoffending against the exact same person.
We might be across purposes.
Okay.
And I don't know. Your data might be offence data, police data, recorded data, which of course might only be 20% of underlying domestic violence. My understanding is that 80% or thereabouts of domestic violence victim survivors do not go to the police, and of the 20, this is women, and it's even higher for men. And of that 20% who go to police, maybe only half of that 20%, i.e. 10% of the victim survivor universe, see charges being laid. So probably more reliable than police data, maybe that's what you're being referred to, would be a personal safety survey, because the data you're referring to still has the same issue with to what extent it depends on police, the intensity and type of police activity, rather than underlying rate. So what I was referring to was an embellishment of the Australian Bureau of Statistics Personal Safety Survey to be able to capture data that would indicate re-victimisation. But I think I've been told that would cost about $3 million a year.
And I can imagine that would be the case. Yeah. But you can see where I'm going here with having more of a victim-centred target. So even if it's, numbers of people turning up to refuges, or it's a dashboard indicator of the actual impact on victim survivors, as opposed to what is quite a narrow and not very useful metric of reoffending as working out, as giving us some indication of the extent of the problem and how well we're doing to tackle it.
I think if we had the money, a broadened personal safety survey would be the way to go, because it's not depending on the level of policing. It is fairly reliable because a complainant there's no incentive to tell fibs in an anonymous survey, and it doesn't depend on the level of police activity. I think your suggestion about using victim data from Boxar or police still suffers the same problem as reoffending, and alternatively numbers going to refuges. To some extent, that may reflect, if there's an increase, that may reflect an increase in the underlying rate of domestic violence, or it may reflect an increased confidence and willingness in victim survivors to find crisis accommodation, or it may reflect the greater availability of accommodation to go to. So probably a survey, an anonymous survey, is the best way to go. But as I've said, there's the...
Yeah, it does sound like it. I think you've convinced me that that's what we should be doing. But I do appreciate there would be an additional cost in that. But perhaps that would give us a better idea.
Well, I might sub you in for the Treasurer.
Just if we had the money... Have you been following what's been happening in ICAC about how 120 million gets thrown here, 170 million gets thrown here, $5.5 million gets thrown here? We're talking about $3 million or so about domestic violence. Reflecting on what we're hearing in ICAC, is it really your answer if we had the money?
Well,
is that really the answer from your government?
That's a colourful and long bow to draw, Mr. Shoebridge.
We're all hearing it.
Well, I'm not going to comment on the matters before ICAC. Others have commented on that. But as a government, we are putting more into fighting domestic violence than any government ever has before, leaving aside our $484 million announcement in relation to accommodation. Our spending in this area is up 27%. But there are always limits any government faces, fiscal challenges, and that's $3 million. If I have a domestic violence budget, $3 million I spend on data collection is $3 million I don't have for something else. And to take Mr. Shoebridge's implicit point, we'll find the money from somewhere else. Well, we've increased spending in this area by 27% this year, and if you add $484 million over 4 years, that's something like an 80% increase in our investment in fighting domestic violence.
And I do totally understand that, but I think it's also important to invest in measures to work out if we're getting things right or wrong. So I would leave that idea with you.
Thank you.
Could I turn to the Reinvest trial funding? Talking about throwing money around. I asked you about this previously, and I do know that Reinvest did want an extra $5.5 million for the next 2 years. They have only received an additional $1.2 million, which is promising, presumably given that the head of Boxar was viewing giving more money to the Reinvest trial as throwing good money after bad. What convinced you to give them more money?
Well, the premise in your question is not correct. Throwing good money after bad. Look. This is an important research project. Just like we are trialling men's behaviour change programs and programs in prisons, this is a trial. We will not know until we get the results of this double-blinded randomised trial whether the use of this antidepressant has any effect or not. But earlier indications where there were suggestions that it might cut offence. It's not just domestic violence; it's about violent offenders generally. It may cut reoffending. So it is a trial worth completing, and we are so close to having results that you may as well stay the course and get it done.
And I guess that's the response that I was thinking you would give, because we've had the discussion about whether or not it's a wrong-headed trial or not, and I don't want to relitigate that. But Boxar, it was the head of Boxar that talked about throwing good money after bad, and in the DCJ documents that I obtained on a order for papers, it revealed that it would cost probably around $13.5 million to actually get proper results. So what has happened, which has led you to believe that the $1.2 million will actually get them to the point of being able to have proper results to be assessed?
There will be a smaller number of participants, I think 200 instead of 400 or more that was suggested previously. But the Kirby Institute assures us that is a large enough participation rate to have robust empirical results.
So does that take into account the high numbers that we're pulling out? Has there been any commitment from the government to help recruit to the trial?
I think certainly community corrections have been asked to keep aware of appropriate cohorts of participants in the areas where this trial is going on. So that's Hunter, Central Coast, Western Sydney and Central Sydney, I think.
And are you aware of magistrates in some cases directing participation in Reinvest?
I'm not aware, but I can't say that it's not happening. I'm not aware one way or the other.
Okay, given that it involves a prescription, we would expect that any direction to participate in the trial would come from a psychologist or a psychiatrist or even a GP rather than a magistrate. If that was going on, would you be concerned?
I don't want to jump at hypotheticals, but prima facie, if it does involve a prescription, you would ordinarily expect it to be on the advice of a medical practitioner or a paramedical practitioner like a psychologist.
And have measures now been put in place to ensure that the victim survivors related to the particular perpetrators are being consulted and that their consent is sought before the perpetrators put on this program?
I don't know about consent, but certainly in evaluation. So I'm told that UNSW has established an advisory group to determine the most appropriate methodology and approach to measure the impact on partners of Reinvest participants. This includes ensuring safety and confidentiality are maintained in the collection of information from victim survivors. Membership includes representatives from Women's Domestic Violence Court Advocacy Service, the Chief Magistrate's Office, UNSW clinical representatives, victim survivor partners and ex-partners, and I'm told that the advisory group is also responsible for overseeing and advising on the trial's adherence to providing partner support and monitoring partner safety and wellbeing.
Thank you. That sounds like an improvement from when we last discussed this, so I will wait and see. Can I ask you about the new shelters? So, as you say, that was a promising announcement made last month. So the plan is for the number of women's refuges to increase from 86 to 161. What will be the increase in actual capacity in refuges? So if these new core and cluster have only 6 units, what's the percentage increase in available accommodation?
I'll make some remarks, if I may, and then I'll invite Ms Campbell to supplement. So I think that represents roughly a doubling in capacity. So typically there will, in these, and the number of 75 is approximate. There'll also be 8 refurbishments of existing refuges to convert them to a core and cluster model. So typically there'd be maybe 4, maybe up to 6, but maybe 4 units at each one of these core and cluster. So you can do the maths from that, how many extra units it provides. I don't know whether Ms Campbell wants to comment on what it represents as what proportion increase in capacity it represents.
Thank you, Attorney. In terms of numbers, it would be an additional 2,900 women and children each year over the 4 years.
Okay, based on what's the current capacity?
The current capacity, wait a second. The current capacity, very similar. So it would be just a little bit more currently, probably closer to 3,500, but I'm happy to take that on notice to give you the exact detail.
Thank you. That would be useful. How many of those will be pet friendly?
That's a good question. I can't give you a precise answer, but Ms Campbell and I have already had a discussion about this and the need to have as many as possible that are pet friendly. So that and accessibility for people with disability will be important parts of the design.
And was consideration given to expanding existing refuges? I hear that there's some refurbishments, but there's a lot of refuges asking for additional funding to expand.
No, but there will be, I anticipate that in the $140 million of New South Wales and Commonwealth extra money over the next 2 financial years, that some of that will be available for infrastructure programs.
The existing orchard facility in Orange that's run, I believe, by Housing Plus, what percentage of that was funded by the New South Wales Government and what percentage was through charitable donations?
I'd have to take that on notice. I don't know whether you know, Ms Campbell.
My understanding is that was funded through the New South Wales homelessness strategy. I'm not exactly sure whether there was any co-contribution, so I'm again happy to take that on notice.
Thank you. Is the plan for these additional shelters to follow a similar sort of part funding model, or will they be fully funded?
I'm not sure about that, but whatever it is, the money, the money we announced, $400 million, is there both for construction and also operation over the forward estimates.
And what criteria will be used to select the providers?
Those criteria are being developed. I think in the near future, Ms Campbell and others will be doing a mapping exercise to identify areas of greatest need.
Many refuges have limited capacity at the moment due to COVID restrictions, and so with the spacing out of rooms and so on. Has that been considered in this core and cluster model for the future?
Would you mind just elaborating on the question?
For example, in some of the refuges that have shared kitchens or any kind of shared area, that has resulted in a lot of the refuges being unable to take as many women and children because they've had to keep them separate during COVID restrictions. Obviously, if we get something like that happening again, it'd be good to future-proof the design. has that been taken into consideration with this core and cluster model?
With them, I don't know, Ms. Campbell?
Yes, thanks, Bernie. Yes, certainly that will be taken into account. We obviously learnt a lot during COVID, and whilst a number of the refuges have had reduced capacity given the design, we've also provided additional COVID funding to enable people to be supported in other arrangements. But in terms of the design of the core and clusters, we'll be doing that in conjunction with DV New South Wales and key stakeholders to look at a co-design. And obviously it'll be very different in different locations across New South Wales. And in terms of having separate units and perhaps looking at arrangements where there's facilities for cooking within the units will be explored over the next little while.
Thank you. Just a final question. In relation to sexual assault claims, for the past couple of years I've been raising with Minister Elliott and Commissioner Fuller the reasons why New South Wales doesn't have the ability to capture the data from when sort of the percentage of how many sexual assault claims are withdrawn by the victim and how many are discontinued, for example, because the prosecution thinks it's unlikely to get a conviction. Although we collect that data, we're the only jurisdiction in Australia not to be able to produce, so we record it, but we can't then extract it. I've been raising it for a very long time. I've been told that now we've got a new system coming in to replace the existing COPS system called IOPS, I think, and that it will have that capacity, but not for an additional 4 years. When I asked the Minister about this on Friday, I asked Commissioner Fuller, they didn't think it was very useful to have that data and didn't think that it was a big priority. Do you think it would be useful to have that data?
Well, thanks for warning me about what they said. Look, you know, you can never get enough data. I'll look at that issue, but as you might recall, part of our response to the Law Reform Commission's recommendations on consent law was a research exercise on the experience of victim survivors in the criminal justice process from go to woe, and certainly dropout rates, if I can call it that, or turnout rates would certainly be an important part of the analysis that the Department and Boxar will be doing.
All right, I'll leave that with you.
Thank you.
Thank you.
Attorney, you're aware that the New South Wales government spent $10.85 million on the ICE inquiry? Are you aware of that?
That sounds about right.
Report delivered now more than 18 months ago, and we still haven't seen a single one of the 109 recommendations implemented.
Not quite right.
Well, we haven't seen the 109 recommendations implemented even in a pretend way. What do you say to the people of New South Wales? Was this a $10.85 million stunt to avoid action?
A couple of things. Firstly, there is the significant, what I call down payment with the announcement of a Dubbo drug court, which is an investment of around $28 million, and that'll be up and running from around about the middle of next year, plus a residential rehab facility in Dubbo. So there is a start, albeit not the overwhelming body of recommendations to be implemented. No, not a stunt at all. Look, if the government were not serious about tackling the problem of drug addiction, particularly in regional New South Wales, we would not have set up an extensive inquiry, hearing evidence from scores of experts going around New South Wales with a leading practitioner as the counsel assisting, a leading practitioner as the commissioner. Obviously, you set up an expert inquiry to get recommendations for government to consider implementing.
Well, Attorney, 109 recommendations. At best, you can point to the partial implementation of 2. The Royal Australian College of Physicians, the Royal Australian College of General Practitioners, the Australian Medical Association, the Royal Australian and New Zealand College of Psychiatrists have all come out in just the last few weeks and said that long-term drug policy failures and delays by your government are responsible for costing lives and damaging communities. What do you say to that august group of bodies about the 18-month delay?
Well, I'm keen to get this resolved as quickly as possible. It is a complex issue. There are, as you say, 109 recommendations. The Department of Communities and Justice, the Ministry of Health, the Police Force, Department of Premier Cabinet have been working very hard to get a great landing place on a response to these recommendations, and I'm hopeful and confident that we'll have something to say before Christmas.
Well, you say hopeful and confident before Christmas. Does that mean there won't be any legislation this year?
Well, no, but I'm not. Depending upon what the recommendations are, there may not be a need for legislation. So take court diversion, for example. Were the government minded to expand the drug court or the merit scheme or circle sentencing or a youth Curie court, you would not need legislation to do that. A Walama court, depending on how you configured it, you may or may not need legislation. Pre-court diversion, if anything were done in that area, you may or may not need legislation. We already have a
possession offences, which is one of the core recommendations. Not putting people in jail because they've got an addiction.
David, let him answer, and he was answering.
Thank you. So we said if you were to decriminalise possession, you would need legislation, and we have said we are not decriminalising possession. Were we to do any part of recommendation 12 about any sort of pre-court diversion, you may or may not need legislation to do that. There is already a scheme for. There's already a scheme in place in New South Wales. I'll start again. There is a scheme that operates at music festivals for people caught with drugs at music festivals, where they receive a criminal infringement notice and pay a $400 fine. In terms, that regulation could apply right across New South Wales. It is capable legally at the moment of applying right across New South Wales, but operationally it's only implemented at music festivals, and of course there have been no music festivals basically for the last 18 months. So without saying where the government may land, there may be no pre-court diversion, there might be other pre-court diversion, but you don't necessarily need legislation to widen the operation of an existing pre-court diversion scheme.
Attorney, do you agree with the thrust of recommendation 12 that people should not be being put in jail and criminalised because they have an addiction problem, and that is a fundamental failure of the criminal justice system? Do you accept that as the thrust of recommendation 12?
As a member of Cabinet, fortunately or unfortunately, I don't have the liberty of being able to express a personal view before Cabinet has decided something on what something might look like. But I am happy to express a general view that a health outcome is generally what should be driving our approach to drug policy in New South Wales. There is plenty of evidence that throwing people in jail is not going to solve their addiction problem. They need treatment and intervention. And that's why we have a merit program in New South Wales, that's why we have drug court in New South Wales, and that's why the government is considering recommendations of the ICE inquiry that may expand court diversion, may expand pre-court diversion. So my general philosophy is pretty clear, but it's not appropriate to agitate before the matter's resolved by Cabinet what permutation or combination of diversion we should adopt in New South Wales.
You accept, Attorney, the position put by those four peak medical bodies that this matter has become more, not less urgent because of lockdown and addiction problems associated with lockdown? Do you accept that that's made the matter more urgent?
I accept there is a need to resolve this in a timely manner, and that's certainly something I'm aiming for.
Break.
You finished?
That might be an appropriate time for a break. So I think we have a...
We'll take a break now and come back at 20 minutes past.
Thank you.
The hour. Wow. 15 minutes.
15-minute break, yeah.
So that the Minister can not answer any more questions. No, sorry.
Shall we proceed? Thank you very much, Chair, and good morning, Attorney.
Good morning.
You've indicated that there's as you've indicated earlier, significant rise in regional domestic violence.
No, I didn't say that.
Well, it was indicated by my colleague that there was an increase in various areas of domestic violence.
I may have conceded that there is an increase in reporting rates to police and convictions for domestic violence in some geographic areas.
Well, that concession is an indication that there's an increase, isn't it?
No, as I've discussed, the number of recorded offences is a function of the underlying rate of offending and the intensity of police activity in prosecuting and getting convictions.
Well, Minister, can I ask you then, does the government have a regional strategy for prevention of domestic violence in recent times? Has it introduced any regional strategy?
Look, not something called a regional strategy, but as part of our overall strategy in combating domestic violence, obviously a key part of that is addressing domestic violence in regional New South Wales, because other things being equal, there tends to be higher rates of domestic and family violence in regional New South Wales compared with Metro Sydney.
The statistics does indicate, Attorney, that there's been an increase in domestic violence. I mean, I'll give you an example. For example, the local government areas of Bathurst, there was an increase from in 2016-2017 from 184 to 2020-21 through 324 of domestic violence cases. So this is a significant increase there. At least that's in regional Bathurst. And in Lithgow, there's a similar increase, 37% increase in Bathurst and 27% increase in Lithgow. Isn't that significant in your mind, Attorney?
Well, as I think I indicated before, where you get big increases in particular police districts, it is likely to reflect increased police activity in those districts. It's inherently implausible, for example, that underlying domestic violence might have gone up 30 or 40% in Bathurst, but be stable in other police districts in New South Wales. So the most likely explanation for a regional or a geographically isolated increase, or a collection of those, is an increase in policing rather than some underlying increase in the actual rate of domestic and family violence.
What are you doing?
Which will just be very clear, I'm not suggesting that the level of domestic and family violence is acceptable, because it is clearly a grossly underreported crime. And the statistics I suggested earlier, that 80% of complainants of victims won't go to police, and of the 20% who do, maybe only 10% see their perpetrator charged. So I'm not suggesting for one moment that there isn't a serious domestic violence problem across the state, but what I am suggesting is when you cherry pick increases in particular geographic areas in reported offending, it is most likely reflecting police activity in that geographic area.
Well, Attorney, reducing offending rates in regional New South Wales, what are you doing to reduce the offending rates in regional New South Wales? Apart from the police, I mean, you've indicated what the police are doing. What are you doing as the Attorney?
Well, everything I've described. In terms of law reform, as Attorney General, wearing my Attorney General hat and not my Minister for Prevention of Domestic and Sexual Violence hat, we've introduced an offence of strangulation, making it much easier to prove strangulation, and that's had hundreds of charges, because we know that strangulation is not only obscene in its own right, but also a red flag for domestic violence homicide. Maybe a third of domestic violence homicide has been preceded by non-fatal strangulation. We've reformed the law of apprehended domestic violence orders, so there's now a default period of 2 years rather than 1 year. You can have indefinite ADVOs. Police can can vary ADVOs even when there's a court ADVO in place. ADVOs can apply to offenders when they come out of jail. We've reformed ADVOs so that it's clear that they capture animal abuse. We've reformed definitions of stalking and intimidation so that it's clear they capture cyber abuse. Intimate partner abuse, for example, we know can often, intimate image abuse, I should say, is often a form of coercion, and we've criminalised that. In relation to domestic violence criminal matters and associated proceedings, court-appointed questioners, rather than having a self-represented defendant ask the questions of the complainant, a presumption in favour of closed courts, and so on. So all that is making it hopefully easier for victim survivors to come forward and make complaints and to hold perpetrators accountable for their actions. What else are we doing? Well, there's the men's behaviour change programs.
Can I ask you then a series of scenarios? I put to you these series of scenarios in regional New South Wales.
So my answer is incomplete, but if you want to go on, that's fine.
Thank you, Attorney. If a domestic violence offender lived in Walgett, where would they participate in the men's behaviour change program?
Ms Campbell might be able to answer that.
There is one in that area. I'm just looking through my notes. Let me just have a look. I'd need to take that one on that.
All right. Well, if a domestic violence offender lived in Coonamble, where would they participate in a men's behaviour change program? I mean, these areas have a high rate of domestic violence in those two regions.
Yes, I can answer that one. So that would be Mission Australia. So this program was expanded throughout Western New South Wales, which includes Dubbo, Coonamble, Broken Hill and Walgett.
And what about if a domestic violence offender lived in Moree Plains?
I'd need to take that one on notice.
Thank you. Minister, why are domestic violence rates increasing in the Bethesda, Lithgow areas?
I
know you indicated that it increased policing, but there is a situation where there's significant increase in those areas. Why are they increasing?
Well, I'm not familiar with the specifics of Bathurst and Lithgow, but as a general proposition, where there is a significant increase in recorded domestic violence offences in a particular locality, but not a general trend of increased recorded domestic violence offences across the state, the more likely explanation for Bathurst and Lithgow is some increased or different police activity. If you'd like me to take the question on notice, so that if there's anything specific about Bathurst and Lithgow that I can impart, I will. But my starting position is that prima facie, where a statistic like that emerges, it is likely to be explained by police activity.
Thank you, Attorney. Can I ask you questions in relation to domestic violence notification scheme? Could you provide an update on the status of the domestic violence notification scheme?
So that scheme was trialled, I think, in 4 police districts and has been discontinued. It didn't appear to be a cost-effective exercise in the way that it was configured. It cost many. Look, I'll take. Just let me supplement the figure if it's wrong. But my recollection is it might have cost some many thousands of dollars, even tens of thousands of dollars per notification. It was not a scheme that had the support of the domestic violence sector, so it was discontinued, which is not to say that we won't in future look at reintroducing a different scheme. But the challenge is making it cost effective on the one hand, but protecting people's privacy on the other hand, so that it's not the case that whenever somebody has a new boyfriend, because it's typically a male who's alleged to be the perpetrator, that gives someone a right to go through that person's criminal record. So that if there is to be some sort of filtering exercise, so there is good cause to disclose the offending history of someone, that's a labour-intensive exercise, and it just didn't seem to be cost-effective in terms of lives saved. Millions of dollars for each service. So that has been discontinued in its current model, but if there's some...
when was that discontinued?
Oh, probably 2019, I think. Yeah, 30 June 2019.
Was there an alternative looked at, an alternative approach?
Well, as I said, we will keep considering whether there is a more cost-effective way to go.
Is there a timeline?
No, there's no timeline on that. But there's no, like I say, I don't get the sense that the domestic violence sector, the frontline workers, are calling for such a scheme. I know that it was modelled on a scheme in the UK, and I think South Australia has recently introduced a scheme like it. But at the moment, we don't have any plans to reintroduce such a scheme, but I'm not ruling it out.
Do you have a preferred option, Attorney?
No, because we haven't really been able to land somewhere which is user-friendly, cost-effective, but at the same time has appropriate protections for people's privacy.
I'll just move on to other matters. Attorney, obviously the pandemic has a significant impact on the entire state, but certainly had on New South Wales Supreme and District Courts. What is the current status of the backlog in criminal trials in the New South Wales District and Supreme Courts?
So in the District Court, it peaked at about 2,100 in 2017. I think pre-COVID it was brought down to around 1,400, and at the moment it's in the high 1,500s.
So how many trials have been delayed?
Have been aborted?
Delayed.
Do you have that number at hand?
So in the Supreme Court, 16 criminal trials were vacated. So that,
I'm sorry?
16.
16.
So that increased the pending caseload to 145 as at August. The Supreme Court, though, is resuming criminal trials as of the 8th of November. And in the District Court, the caseload increased to 1,591 in September of 21. That's compared to 1,400 in March 2020. And they've resumed trials as of the 25th of October.
When do you expect the backlog of trials to be cleared, Attorney?
Well, it depends what you mean by cleared. If you mean down to zero, never. If you mean back to where it was pre-COVID.
Well, effectively, those increases that have been delayed addressed.
So when will it be back to 1,400, which it was pre-COVID? My guess would it might take a year to do that. What do you say?
At this point, we haven't forecast the exact amount of time it would take, but the Chief Judge in the District Court has started a program of work in order to shorten vacation, for example, so that they can resume the trials get back on top of the trials as quickly as possible.
Well, in terms of the Chief Justice, in the New South Wales District Court, and Chief Justice have made requests to the government for additional jury rooms. Are you aware of that, Attorney?
Yes.
What have you done about it?
So in order to resume jury trials, we've done a series of things, one of which was to take a look at possibly renting spaces off-site where we have to maintain the 4 square metre rule. Once we get down below the 2 square metre rule, we will be able to actually resume pretty much 100% of the jury trials that we could do pre-COVID. So it's just when we're at the 4 square metre rule that we have a problem.
Just on the issue of courts, Earlier this year, I was approached by a group of practitioners in Newcastle who were concerned that in order for their clients to have reasonable timeframes for trials in both, I think, the Supreme and District Courts, they had to file in the Sydney Registry rather than being able to file locally due to the lack of sitting days anywhere near Newcastle. Is that something that's come to your attention?
No, it hasn't.
Is it something you'd be interested in looking at, about whether or not the burden of trials could be lifted from Sydney Metro and maybe Newcastle could become at least for clientele in Newcastle, they'd be able to have cases heard closer to where they live?
Look, I'm happy to have a look at it. The total resourcing that the District Court gets is in the hands of the Executive, including me. How the court allocates those resources, including where it chooses to list matters, is a matter for the Chief Judge.
Okay, so this is a matter perhaps local law societies and bar associations should speak with the heads of jurisdiction about.
I think it would be, yes. Is it an issue about the local court and the District Court, or just the District Court?
I think it's mainly the District Court and, of course, the lack of Supreme Court sittings.
So I think the Chief Judge would have a user group, and your practitioner colleagues are best to speak to that group and the Chief Judge, I think.
Okay. My friend was asking you some questions about spikes in DV rates in particular localities, and you were saying, I think, the most likely explanation is an increase in policing. You've taken, I think, the examples he's given you on notice to sort of see whether or not it is policing related or whether it has got some other feature. For example, Eurobadala, I think, did you give him the example?
Yeah.
Eurobadala's gone up by nearly 11% a year over 5 years, but more recently, the 2-year average is a 39% increase. If you look at, for example, Parramatta's nearly up by 7%, Penrith 4%, but Tenterfield 12% over per year over 5 years, but nearly 77% over the last 2 years. These are very, as you say, quite dramatic increases. If I put these on as supplementary questions, will you come back with a full explanation about whether it is policing related or whether there's some other
I'll do my
things
best.
Okay, that's fine.
Yeah. Can I just ask you questions in relation to the Lunar Park inquiry? Yeah?
Yep.
Do you support such an inquiry?
Again, as a member of Cabinet, I don't have the luxury of expressing personal opinions. At the moment, there's no government proposal for an inquiry. I think the coroner has asked. So I have responsibility for the Coroner's Act. I otherwise don't have portfolio responsibility for a police investigation, a special commission of inquiry or a royal commission of matters for the Premier, rather than me. My understanding is the coroner has asked the police to provide a report to her, and I haven't received a recent update on that.
Well, the Treasurer had no difficulty expressing his views, his strong views, that there should be an independent inquiry.
That doesn't make it right.
Are you in a separate category to the Treasurer?
Look, I'm not going to comment on what the Treasurer does, but I'm a traditionalist. There are plenty of things I'd like to say. There are plenty of things that I might put in my memoirs one day, but for the moment...
Yeah, can I just go back to a couple of questions that I've got, Attorney?
Sure.
In March, you said that you had asked the Department of Communities and Justice for advice on any appropriate action. What advice have you received?
Well, among other things, a special commission of inquiry and a royal commission their matters for the Premier. The coroner can reopen the matter, and at the moment, the coroner has asked the police to provide her with a report.
Having received the advice, have you acted on any aspect of the advice?
No, because I'm not the coroner. It's a matter for the coroner to request a report from the police. It's a matter for the police to decide what they want to independently investigate or to respond to the coroner's request, and it's a matter for the Premier to decide whether to hold a royal commission or a special commission of inquiry.
Well, the former Premier was considering an inquiry. Is the current Premier also supportive of an inquiry?
You'd have to ask him that.
Has there been any discussions?
I've not had a discussion with him, no.
I'll pass it over to you.
Righty. Mohammed Scaff, he's been released now on bail, on parole, is that correct?
Correct.
previously the indications that were that he still posed a medium to high level of risk to the community, and yet, despite that, he has. I think the submissions of the Crown to the parole authority was that he should be released on conditions. Now, was that because of the lack of extended programs to reintegrate him? Is that because they'd been cancelled due to COVID?
Firstly, it's not my portfolio. It's the corrections.
You're the minister responsible for the parole authority, though, aren't you?
No, I'm not. No. So I am responsible for appointments of what I call judicial members to the parole authority. Mm-hmm. The appointment of community members is the responsibility of the corrections minister, and the day-to-day operations of the state parole authority are his responsibility. And I don't play any role in submissions that are made to the state parole authority about parole or otherwise for offenders who are in custody.
We might come back to that.
Okay.
Attorney, you were asked some questions by Mr. Searle earlier today about the monitoring devices that are used in one notorious bail case recently. Are those monitoring devices provided by a private corporation, and if so, who?
My understanding was in the case to which you refer, it was a private company providing the device. I don't know the identity of that company.
Can Ms. Delia help us? Or
I would have to take it on notice.
Are you seeking a review of the contract with that private company if, as appears in this case, at least according to your comments, the accused was able to cut it off and then abscond?
Well, look, I don't understand there is a contract between the state and the private company. It's rather, I'd have to check what the bail conditions are. I don't understand we've contracted with that company. Is that correct? I say we, not me. The prosecutor, it was the Commonwealth DPP in that case, is not proffering electronic monitoring as a solution to bail risk. That is something that the accused proffered. So who arranged for the private monitoring of the accused? I'll have to take that on notice. Do you know?
Was it? It can't have just been a private contract between the accused and some third party.
I wasn't involved in running that case. I'll have to take that question on notice.
Well, Mr. McKnight, do you know the circumstances in which private corporations are having the role of monitoring people on bail in New South Wales? I mean, you must have some oversight of it. It can't just be happening entirely free from any oversight from you.
So the situation is, as I understand it, is as the AG has explained it, the department has contracts with electronic monitoring arrangements when the person is in corrections, in the care of corrections. So in the situation of extended supervision orders or ICOs that involve electronic monitoring, corrections have contracts with monitoring agencies. The bail situation is relatively unusual, as I understand it, and the situation is as the AG has explained it.
That it's just, there's no contract, no outstanding arrangement. They're just sort of freelancing, are they, with whoever they choose to have private monitoring? It's a freelancing situation.
I think we need to take the detail of what happened in this case on notice.
Ms. Delia, can you shed any light on this?
I can't, no, sorry.
But I think
so right now, as far as your understanding, attorney, is that there are private arrangements entered into with private corporations unrelated to a contract with the people of New South Wales, under which, if you're wealthy enough, you can have your bail monitored. And in circumstances when you can just then cut off the monitor and go for a run?
Well, look, a number of responses to that. Firstly, as a general proposition, prosecutors on behalf of the state do not support electronic monitoring as a risk mitigation condition for bail. They would generally oppose bail being granted. So this is not something that the state proffers. Secondly, this was a case involving the Commonwealth Director of Public Prosecutions, not the state. Thirdly, because I'm not wasn't involved in the case, I don't know what the mechanism was to make the undertaking to be monitored enforceable, how it was enforced as against the private company. But that's not to say there wasn't some enforcement mechanism. I just don't know what it was.
Well, Attorney,
because it was a matter between the Commonwealth DPP and this private accused.
Well, how do you know it was a matter between the Commonwealth DPP and the private accused? Let me finish.
Yeah, sorry.
How do you know it was a matter between the Commonwealth DPP and the accused if you don't know even the identity of the corporation that was doing the monitoring? And I assume you haven't got a copy of the order in front of you. So how do you know it was an arrangement between the Commonwealth DPP and the accused?
Well, I don't know if it's an arrangement. What I'm saying is it's not a bail application that the state was running and opposing. It was being run and it was being opposed by the Commonwealth DPP because they were federal charges. So what contract or undertaking was entered into by a private company to the Commonwealth DPP or to the Commonwealth, I don't know, because I wasn't involved and I haven't, in the time available, be able to descend to that level of detail.
It's not the Commonwealth DPP that's going to be monitoring whether or not bail's complied with. It's the New South Wales Police Force, I assume, that's going to be monitoring whether bail's complied with, or have I got something wrong? Does the Commonwealth DPP have a role that I don't understand?
Just to be clear, I'm not saying there's some kind of total vacuum that a private company just says it'll do something and there is no enforcement mechanism. I'm just saying I don't know what that mechanism is, and we'll take that question on notice.
So what we do know at the moment is there's some private company that you don't know the details of that's monitoring an accused under serious drug offences. The accused cut off the private monitoring device, and you don't know whose job it was to monitor it, what the arrangements were under which the device was put in place, and what, if any, role the New South Wales Police had in it. Well, that's the state of play at the moment, is it, Attorney?
Well, my job as attorney is not to run every one of the tens of thousands of bail applications that are made in New South Wales, so I don't think it's reasonable to expect that I would know all that detail, if in fact that's what you're suggesting. But the case illustrates a problem with electronic monitoring on a bail application where there is a significant flight risk of an accused. It really wouldn't matter on one view whether it was community corrections or corrective services monitoring the device or a private company. As I understand it, once the accused cut the device, an alarm was sounded and police were trying to swoop on his residence straight away, but they weren't there quick enough. So I don't think anything turned on whether it was private or community corrections or corrective services. But in any event, that is quite different from the arrangements that are in place with parole, where corrective services operate and monitor those devices.
Don't you accept that on the face of it, we've got a significant problem here with privatising and contracting out a key part of the criminal justice system, in this case a private corporation, having the bail monitoring? No. You're not troubled by that?
No. The issue that has emerged is that electronic monitoring, in this case, was not an effective risk mitigator because, notwithstanding the electronic monitoring, the offender, or the accused, I should say, absconded. But that would be
I think
the
once
same.
David, sorry. I think once you abscond, you become an offender. But anyhow.
Well. The accused, the offender, that would be an issue whether the monitoring was private or public. The issue is that the offender, the accused, was able to cut his device and abscond, which would be the same issue whether it was private or public monitoring. The issue is there that the police moved as swiftly as possible, as swiftly as they would if it were publicly monitored instead of privately monitored. So the private versus public issue made no difference in this case. The problem was with using electronic monitoring as a device to minimise risk. Now, I'm not, in saying that, advocating private monitoring for anything, because The state has never, as I understand it, has never advocated private electronic monitoring in a bail application. Rather, the state typically, or the prosecution typically opposes bail, notwithstanding that the accused offers to have electronic monitoring. And the reason it's private is because the state is saying, well, we're not going to do it, we don't want it. And the accused offers it and persuades a judicial officer that that's an appropriate term of bail to justify the granting of bail.
Is it, Tony, you seem to know quite a bit about it. You know about the delay, and you say that there's no difference between the delay in response to this private arrangement than there is to a public arrangement. How do you know that?
Only from what I've read. I don't know that. I don't know that firsthand.
So can we rely upon your evidence that there's no difference between the delay No, let me finish.
No, go on.
No difference in the delay between this private reports of this private device being cut and any tampering with a public device. Can we rely upon your evidence that there's no difference in a delay?
Well, that is second-hand evidence. That's my understanding. But the point, I think the point you're trying to make is that this is an argument against privatising electronic monitoring. The state is not trying to privatise electronic monitoring. Electronic monitoring of parolees and domestic violence offenders under a pilot is, as I understand it, done by corrective services. This is not electronic monitoring of those who want bail is not a scheme thought up by the state or promoted by the state. It occurs over the opposition of prosecutors, but at the submission of individual accused who are able to persuade a judicial officer that bail is appropriate because the risk is mitigated by electronic monitoring, and they are prepared to pay for it themselves.
So if you're wealthy enough at the moment, this bloke obviously had a lot of money. If you're wealthy enough, you can pay for the private monitoring of your bail, and there's no prohibition on that under the New South Wales Criminal Procedure Act or the like. If you're wealthy enough, you can just pay for your own private monitoring. Is that the situation?
Well, if you're wealthy enough, but that doesn't mean you get bail. And I would imagine, given the circumstances of what happened last week, every prosecutor is going to say, look what happened last time. You, the judicial officer, would be unwise to grant bail.
Under a privately monitored, contracted out arrangement paid for by the defendant.
That's right. And the state is not going to propose electronic monitoring. It's going to be an accused who says there's no risk. Let me be electronically monitored, and even better, it won't cost the state a cent. I'll pay for it.
How many times has it happened in the last, in the last financial year and the financial year before that? How many times has it happened?
It being someone on bail?
Being privately monitored?
I'd have to take that on notice. I'm not aware of any...
Do you accept this now?
He's continuing.
No, there was a pause and I stepped over him. Sorry, Attorney. You're not aware?
I'm not aware of others, but that's not to say there aren't others.
And despite the briefing you got, you weren't told which company it was that provided the monitoring?
Look, I may have been. I've just unfortunately, at my ripe old age, I can't remember everything.
You could find that information before 1 o'clock. It would be useful, Attorney. There's a fair bit of support over there, I'd point to. Attorney... He's
got 21 days in which to respond to questions.
Order, interjection.
No, but something as simple as the name of the corporate entity should be able to be provided within an hour with goodwill on your part, Attorney. So I'd invite you to endeavour. Attorney, I was asking you questions earlier about what's happening with raising the age of criminal responsibility, and you said that there's a federal process through CAG or MAG that's working its way through. Do you remember that?
Yes.
And that's grinding to indecision would be a fair summary of that, isn't it? It's grinding to a slow lack of consensus.
No, I think it is reaching a crescendo that will either result in some sort of consensus or an acceptance that consensus is not going to be achieved and each jurisdiction should make its own decision.
Well, if I remember your summary of matters correctly, Queensland said no. The ACT has said maybe 12 years. So the ACT is moving on 14 years, and the Northern Territory has said maybe 12 years, but that's under review. Is that a
I think,
summary of it?
Yeah, so
no for Queensland, 14 for ACT, and maybe 12 for the Northern Territory.
So I think the Northern Territory, before this process started, had indicated, I think, an in-principle decision to go to 12.
Yeah. So 10 in Queensland, 14 in the ACT, and 12 in the Northern Territory. That's the current state of play?
That's the current state of play.
And deafening silence in terms of a position from WA, South Australia, New South Wales, Victoria and Tasmania. Is that the state of play?
Those other jurisdictions haven't declared a position.
That is rapidly moving towards non-consensus. Even if we just look at Queensland, the Northern Territory and the ACT, they're not agreeing. Are we really going to wait for this thing to totally unravel, or as you say, hit a crescendo of non-consensus before we start acting? Is that your position?
Well, I don't think the ministers from the different jurisdictions have reached the point yet where we have agreed to disagree or can't progress the matter. I think the possibility of a consensus is still a real possibility, but it will get to the point sooner rather than later where we just say, well, look, we're never going to agree, and each jurisdiction should make its own decision.
Do you think it's right that 10-year-old children who still have their milk teeth are being brought before New South Wales courts and trialled for crimes? Do you think that's right? 10-year-old kids still with their milk teeth being brought before New South Wales courts and tried for crime?
I can't comment on what might be before Cabinet, and I can't breach the confidence of exchanges that I've had with my fellow Attorneys General around the country. But as a general proposition, a 10-year-old, at least generally speaking, and the question will be whether it should be never the case, but at least generally speaking, a 10-year-old would not have the capacity to have criminal responsibility for just about anything. That I think is well recognised. Whether that should be an absolute bar on prosecuting a 10-year-old is a matter that obviously I'm discussing with my colleagues and eventually will come to the New South Wales Cabinet.
Attorney, are you aware of at least one study, and I'm sorry I haven't got it in front of me, that has shown that there's been a significant decline in incarceration of young people during COVID and absolutely no associated rise in crime or associated antisocial problems during that period where we've had a significant decline in the number of young people in incarceration?
Not specifically, but I am aware that notwithstanding the decline in incarceration for adult offenders, there has been no increase in underlying crime rates as a general proposition. So I would imagine the same would be true for young offenders.
Yeah. Well, indeed it is my understanding. Given that, will your government be feeding that kind of information in, that kind of very real empirical information, that jailing kids isn't the answer to juvenile crime? Will you be feeding that information into the Cabinet decision about raising the age?
Well, that's certainly a relevant consideration, as is the correlation between the first age at which somebody has contact with the criminal justice system and their likelihood of offending throughout their life. There's certainly matters that are relevant to any decision we make.
And when you say the correlation, the unambiguous evidence that the earlier you're dragged into the criminal justice system, the far more likely it is you're going to have a lifetime involvement in the criminal justice system.
Other things being equal, there is a significant correlation between the age at which somebody first encounters the criminal justice system on the one hand and the likelihood of offending throughout their lifetime.
Attorney, is another factor, do you acknowledge another factor in this? That right now as we speak, I think 43% of the young people in juvenile detention are First Nations kids. 43%.
That's correct.
Do you acknowledge that failing to act on raising the age is going to mean it is next to impossible to meet the targets on closing the gap?
Those closing the gap targets are very challenging, and that's why, as a government, we have to push the envelope as much as we can and look at matters like the age of criminal responsibility. Where Cabinet lands on that, and is a matter I've got to discuss with my cabinet colleagues. Where we land potentially interjurisdictionally, again, is matters that are on the table with my ministerial colleagues in other jurisdictions at the moment.
But do you accept these two things are linked? Raising the age and closing the gap, that they are inextricably linked? Do you accept that?
Yeah, I accept that there is significant evidence of a strong correlation between the first age at which somebody enters or encounters the criminal justice system on the one hand, and the likelihood of offending and having other problems in their life throughout their life on the other hand. That is equally true of Indigenous young offenders.
But what's not equally true of Indigenous and non-Indigenous offenders is the fact that if you're a young teenage First Nations person in this state, you are something in the order of 15 times more likely to be in jail tonight and 15 times more likely to be caught up in the criminal justice system if you're aged 10, 11, 12 or 13. That is something. Is that something you're going to take on board in your decision making on this?
So that overrepresentation is very clear. If the correlation I've described is true for the general young offending population, then it is equally true for the Indigenous offending population, and it's something that obviously you've got to take into account.
Thank you, Mr. Chair. Mr. Attorney, I just wanted to take you back to, I think, some answers you gave in response to questions from my colleague, the Honourable Shaket Mosselman, about the domestic violence notification scheme. Did you say that that scheme had been discontinued this year?
Yes, it was discontinued on 30 June 2019.
Can you tell us why it was discontinued?
I hope I had articulated that earlier, but I'll have another go. It didn't appear to be a cost-effective exercise. The cost per notification was in the many thousands. If you'd like, I can give you a more...
That'd be good. If you could do that on notice.
Yeah, take what the figure was. There weren't a lot of notifications. It was trialled in 4 local area commands, and so it was discontinued for that reason. In 2019, and my impression is that it didn't have much sector support. They thought there were better ways to spend money on tackling domestic violence than on this notification scheme.
And the DV Death Review Team report, recommendation 30, was that there should be a review of the notification scheme. Was there a working group established to do that review? And is there a document that embodies that?
I don't know the answer to each of those. I can't recall the answer to each of those questions.
Okay, well, if you could take those on notice. Okay. So was there a review of the scheme? Who participated in that review? Who was consulted? And is there a report that we can have a read of?
There is, Mr McKnight reminds me, there is a publicly available evaluation. Mm-hmm. It's on the Women New South Wales website.
Okay.
I can read out the link if you like, or we'll send it to you.
All right, well, I'll change my questions to the report of the Legislative Council on the high level of First Nations deaths in custody, which I know you must have had some involvement in the government response. My friend, Mr Shoebridge, was asking you some questions about the age of criminal responsibility, which was recommendation 11. And Mr Attorney, there's a number of members of this committee, Mr Khan, Mr Shoebridge and myself, who were on that. We're also on the Select Committee inquiry for O'Neill jurisdiction. Can you tell us, do you have a time frame by which the New South Wales government will reach a view about whether there is likely to be consensus amongst the attorneys of Australia, or whether the state will do its own thing?
I can't give you a precise time frame, but I would be disappointed if New South Wales has not decided its position in this term of Parliament, and more specifically within the next several months.
Okay. I mean, I raised the issue because it's not a stranger to those deliberations. I think in the mid to late 90s, when I was a staffer to a previous attorney, this was a sort of standing item on, I think, the agenda of what was then called SCAG. So it's not a new issue, but you think it may come to some finalisation in the next 12 months? From the New South Wales government's
I think
perspective?
So. Yeah, I think so. I can't say what that finalisation will be, but I think we will get to the point sooner rather than later where either there is a consensus, and it may not be, given the points that Mr Shoebridge raised, it may not be unanimity, but there might be a significant majority consensus at a interjurisdictional level, or we may give up on that and each jurisdiction goes its own way.
For example, I think the ACT has already indicated I think they're going to go their own way.
They've already made the, and in fact, they're very far down the path with discussion papers and planning to get to 14.
Yeah.
Mr Attorney, a number of recommendations made by that inquiry, recommendations 8 to 13, dealt with changes or proposed changes to the criminal justice system, and the government response recently provided indicates that these recommendations remain, quote, under consideration. Again, I understand these are complex issues, but do you have a time frame by which the Parliament might receive a substantive response by the government to those particular items which cover the Bail Act, Summary Offences Act, the Age of Criminal Responsibility, Young Offenders Act, LEPRA, for example?
The minimum age of criminal responsibility we've discussed.
Yeah.
The Bail Act review, I would hope within the next 6 months. Mm-hmm. The Young Offenders Act is very well advanced, the review of that. I would hope within the next few months. What else was on your list?
Well, there's the number of additional recommendations that...
Summary Offences Act, I don't see any movement there for the foreseeable future.
Mm-hmm. All right, there's a number of recommendations made that touch on the operation of the Coroner's Court, and I think the government response indicates that a number of those remain under consideration in the context of the statutory review of the Coroner's Act 2009. That review's been ongoing since 2014.
Yes.
Do you have a time horizon by which we may expect the completion of that review?
Look, no, I can't give you any particular date.
Mm-hmm. Not this year, then?
I wouldn't expect this year, no.
Next year?
Quite possibly, or even probably, yeah.
Okay. One of the things that came up in the First Nations inquiry was the significant delays in the coronial jurisdiction. And again, none of this is a reflection on the professionalism of the coroners, but there did seem to be clear evidence about a lack of resourcing for that jurisdiction. And I know we might have had a debate about this, but the evidence from, for example, Victoria and Queensland is that they seem to substantially resource their coroner's jurisdiction more. I think there are like 20 coroners in Queensland. Now, I know you've got a number of full-time permanent coroners in New South Wales, and then you've got country magistrates doing coronial work. But the evidence the Select Committee has received so far is that 80% of the coronial work is still done by the permanent coroners, and the country coroners really do 20%. It's not an insignificant amount, but it's still the minority of that work. Do you have plans to improve the resources of the coronial jurisdiction over the next 12, 18 months?
Well, look, in replying to your question, don't take me as accepting the premise of your question that...
No, you didn't previously, so I'd expect nothing else.
Victoria and Queensland are comparable because they have a standalone coroner's court, whereas here in New South Wales it's a jurisdiction of the local court.
Yeah, but even allowing for that, Mr Attorney, they seem to have more judicial officers.
Well, there's also the issue of what country magistrates do, which you've alluded to. So we announced in the last budget there'd be an extra full-time magistrate to act as a full-time coroner, which will improve resourcing.
That's what, 6 now in New South Wales?
I think 6 will go to 7, I think, thereabouts. Coronial processes generally, there's been greater centralisation at Lithgow compared with previously. We have amended the law, the requirement that if someone hadn't seen a doctor within 6 months, it is reportable. That has gone. So I think there are significant procedures that the task force is looking at. So there's a task force that Mr. Follett of the Department of Communities and Justice and Dr. Kerry Chant, the Chief Health Officer, are co-chairing, looking at ways to improve coronial processes. So that task force will probably finish its business in the next in this financial year. So the statutory review report will probably await the outcomes of that task force's report, but that's a sample of what we're doing.
Okay.
I think Ms. Delia wanted to add something.
Just to add, with respect to the performance of the New South Wales court in comparison to Victoria, when we take a look at ROGs, New South Wales actually is performing better than Victoria at this point in time.
That's only on completion rates, isn't it? And if you don't do an investigation or you do a paper investigation, it helps your completion rates.
On finalisations?
Yeah. That's not a good measure, is it, Ms. Delia?
Well, it's an incomplete measure, I think, is what Mr. Shoebridge might be.
It's a finalisation within a time period.
All right, Mr. Attorney, we might return to the issue. In relation to the statutory review, there's a draft review document, isn't there, that has been completed?
There is, I imagine there is a draft, yes. Oh, sorry, there would be a draft, yes.
I think I've written to you about this matter. I'll await your response before taking the matter up further. One of the other recommendations by the First Nations Deaths in Custody Select Committee was around the Wallumer Court as part of the District Court. Now, I know, has the government made any decision about proceeding with the Wallumer Court proposal?
No, so that's a recommendation of your inquiry.
It was also a recommendation, I think, of the ICE inquiry.
Yep.
It's been supported by the Bar Association, the Law Society, other civil society groups, and I may be misremembering, although you might have had some reservations. I think you might have made positive comments.
No, I think I was speculating about other people's reservations and used a colourful expression that...
The apartheid system of justice.
Yes.
So that's not your view?
That's not my view, no.
So you've got a positive view of the Wallumer Court idea?
Look, I think it is a Wallumer proposal is certainly something I'm very interested in. I don't think at the moment it has the empirical underpinning that some of its proponents say. But notwithstanding that, given the kind of point that Mr. Shoebridge was making, how are we going to close the gap? How are we going to get these targets achieved? These sorts of proposals are certainly worth investigating, and unless you give them a go, you'll never know whether they will reduce reoffending. Well, the other thing, it's not just about reducing reoffending. It's also about First Nations people having confidence in the judicial process, which is another potentially attractive feature of a Wallumer proposal, just like a Koori Court or Justice Reinvestment in Burke. Proposals like that, if they reduce reoffending, that's terrific, but they also have merit if they improve community cohesion and confidence in the justice system.
Yes, well, I mean, we know that the current approach to criminal justice and First Nations people is having, some severe negative effects. Notwithstanding the criminality issue, there's a problem, there's a lack of trust by the community in the criminal justice system. You mentioned the lack of an evidence base in support of Wallumer proposals, but there was no equivalent evidence base behind the Youth Koori Court. But, nevertheless, that's now, I think, up and running in Surrey Hills and in Parramatta and has broad civil society acceptance and support. The same consideration should be extended to the Wallumer proposal, shouldn't it? I mean, we know what's theirs now is not working and there are problems. So maybe we should try something innovative and different? Well,
I'll have more to say in the next few weeks. But
about the Wallumer proposal?
Well, potentially. Look, the point you make is a good point. And when I say there is no empirical base at the moment, I wasn't saying that therefore the government has decided for that reason not to embark on it. What proponents do is say that because this is they point to the success of circle sentencing, they point to the success of the drug court and extrapolate from those successes the likelihood of success for our Walama court. So when I say there's no empirical underpinning, there's that by extrapolation, but there's no empirical underpinning for an Indigenous, an approach to an Indigenous court at an intermediate court level. But that said, as you have said, you will never know unless you try.
Well,
we'll develop that point in the future.
Okay. Well, just on that, it's the case, isn't it, in December 2018, ahead of the most recent state election, your department prepared a business case showing potential savings of over 6 to 8 years of more than $16 million on prison beds and nearly $6 million from a reduction in recidivism rates arising from something like a Walama proposal. Wasn't that the case?
Well,
not an evidence base, but it's some costings.
Yeah. So look, that is assuming a reduction in reoffending, for which there is not an empirical base. But I want to be very clear. I'm not saying for that reason you don't try something. You know, just like we have tried what's your plan, which has not been successful. Just like we are trying reinvest in the domestic violence space. Unless you try these things, you will never know whether they work. And when you have such a desperate overrepresentation of Indigenous people in the criminal justice system and targets for 2031 that are very challenging to meet, then you have to seriously look at alternatives and see whether they will work.
And it's hard to develop an evidence base for something that's not in operation either here or indeed in somewhere else, like when you're trying something totally new.
That is self-evidently correct.
Okay. So if I've understood what you've said, we should expect to hear something in this space soon?
The decision will be made imminently, and I hope to have something to say before Christmas.
It'll be a busy few months before Christmas for you, Attorney.
Well, it is.
Attorney, I'll just use a couple of minutes left for us to ask a couple of questions on your announcement on the 19th of October to provide additional 75 women's shelters.
Yes.
The funding allows for an average of 5.7 million per shelter over 4 years. How much of that funding will be operational costs?
I'd have to check your maths where it's 5.7, but whatever the average is, very roughly, about half is construction and half operation, very roughly.
And will the refugees go to tender?
There'll be some tendering process, yes.
And when will that start?
I suspect that'll be a staged process because when not all 75 will come online at once, we want to have a staggered process.
And that's my question. The next follow-up question is that in 2021 or 2022, what numbers will be delivered in, say, 2022?
I'll have to take that on notice.
2023.
I'll have to take notice, but all this will be preceded by a mapping exercise to work out where, in broad terms, where the best locations are for 75 or so women's shelters.
Has it been mapped out yet as to...
That mapping exercise hasn't been completed. I mean, for example, this is not to limit it by any way, but Dubbo and Newcastle, for example, have been identified as particularly areas of high need. There'll be many, many others, but we'll complete that exercise.
Is there particular criteria you're using for allocations?
Oh, well, among other things, it would be a number of women who are turned away and can't be accommodated. Unmet need.
And will they have to reapply every 4 years for the funding?
Look, we haven't worked out what the funding cycle will be. Specialist Homelessness Services, I think, were recommissioned in July to 2024. Ms Campbell is nodding her head. I think it's fairly clear that non-government organisations that contract with us want some funding certainty. So we want to move away as much as possible from the kind of annual cycle of funding, and come April or May, services wondering whether they're going to get funded for another 12 months. It not only does it create angst and uncertainty, it also affects their ability to keep staff if they can't have forward contracts. So I would envisage we would have a cycle of at least 3 years. It might be up to 5 years. It would be in that ballpark.
And how many how many women would be in each refuge are you looking at?
Well, I think Ms Campbell said 2,900 a year.
In the 75?
Yeah.
Would they also accommodate women and children?
That's right, women and children.
Okay. Do you have any more questions? How long do we have? I might have a question for the Crown Solicitor. In relation to the Monero farming system's return to order, where the upper house asked for certain documents, there was one document that was at issue, which was a memo by a public servant who was concerned about a so-called contract with Monero Farming Systems might be a grant, and there was some legal advice sought from you as Crown Solicitor. So I know your general position about not wanting to talk about advice to clients, but this advice, including your written advice, was the subject of a privilege claim. It went through the arbitral process in the upper house, and the government did not succeed in maintaining restricted access to those documents, including your advice. So the access to that is now unrestricted. I was interested in the advice that you provided about whether or not there was privilege over that particular memo. In your advice, you didn't talk about the potential fraud exception. Why was that?
Are you able to share with me a copy of that advice?
I don't have a copy of your advice to hand, but it's got your signature on it, and it's been through a disputation process in the upper house. I can't believe you wouldn't
have it sent to the Crown over the next 20 minutes.
We could have it sent to the Crown, but of course we're about to run out of time. Do you recall giving advice on this issue?
I think I do, but I don't recall. I don't have the specific.
Okay. Well, perhaps you could answer us on notice about why, in giving what was a very otherwise comprehensive advice, you didn't, given the subject matter of the memo, and I'll provide the Secretariat a copy of the memo to refresh your memory. Why, given the nature of the issues raised by that public servant, the concerns they expressed, why in your otherwise comprehensive advice you did not discuss the exceptions to whether or not legal professional privilege could be maintained over that document? I can't take it any further today. We'll come back to that.
Sorry, just so I can clarify, is your question about the advice or the privilege?
No, it's about your advice in providing advice to your client, and your advice is now a public document and we can provide it to you. Why did you not discuss the exceptions to privilege, particularly the potential fraud exception, given the nature of the issues of concern raised by the public servant?
I think, Mr Smith, you take that on notice. Ms Smith, you take that on notice, is the appropriate answer at this point.
I'm not sure what I can add to the advice itself.
Well, you can, to put it directly, you can tell us why you didn't give an advice on the potential presence of the exceptions. You've given a comprehensive advice, you've made a certain recommendation, but I won't take it any further because it's in Mr Shoebridge's time.
Just to be clear, Ms Smith, did you take that on notice?
I can take it on notice. I'm just saying I'm not sure what else I can add.
Well,
I don't
you
know
can answer the question.
The advice will speak for itself.
Well, not the absences from the advice.
Ms Smith, I think the question was about what was not in the advice, which is, I assume, what you've taken on notice, answering about why there was an absence of any consideration of the fraud exception. Is that what you've taken on notice?
Yeah, but I don't know if I can add much to that. If it's not there, it's not there.
The question is, why is it not there?
Anyhow, we'll find out in due course. Attorney, do you have the name of the private corporation who had the easy-to-remove bracelet?
Attenti, ATTENTI Group, previously known as 3M.
Previously known as 3M?
Yep.
So it was like a post-it note, was it? I'll take that as a no. No. Attorney, in May of 2019, according to findings of the Law Enforcement Conduct Commission, 2 members of the New South Wales Police Force Strike Force Raptor over 2 days, engaged in the deliberate, deceitful and malicious harassment of a solicitor trying to go about his business and represent a client before the local court. What have you done to protect the administration of justice in relation to that matter?
So the LEC recommended that the Police Commissioner take reviewable action under, I think it's Section 173 of the Police Act. LEC did not recommend, I don't think it recommended one way or the other, whether the DPP should look at prosecuting the police officers in question. I wrote to the Police Commissioner this year, I think, asking him what he was going to do. He has replied to me that he is not taking reviewable action. He took unreviewable action, I think it is, which is issued a warning to the police officers in question. A group called Defence Lawyers with a Mr Kirkasharian has corresponded to me about potential amendments to the Crimes Act, and I'm looking at that at the moment. The suggestion is that interfering with a public official should extend to private lawyers. There are already offences in criminal legislation that could apply to interfering with or intimidating a private lawyer. They might include stalking or intimidation. They might include perverting the course of justice. But there is a proposal to expand the definition of public official to private lawyers, and that's something that I'm looking at, getting advice on at the moment. And
or at least officers of the court. I mean, that's...
Well, they are officers of the court, so they're not in the same position as judicial officers, for example, but they are officers of the court who are, fulfilling, in one sense, a public duty representing their client. As the LEC Commissioner observed, however much you may have a distaste for clients, it's no justification for interfering with legal representation. Everyone is entitled to legal representation. What occurred to that solicitor was quite reprehensible, and I'm looking at the matter further.
Well, Attorney, indeed, as the magistrate said on the record to the police, I think the quote was, "Are you going to attack a magistrate next?" to the members of Strikeforce Raptor. Is that what it's going to take before you act?
No, as
police
I said,
attacking a magistrate?
As I said, I've said what I'm considering, and that's under consideration.
Well, you've said you're considering potentially changing the criminal law. That's going to do nothing at all to hold to account 2 members of the New South Wales Police Force who, in the findings of the LEC, over 2 separate days engaged in deliberate, deceitful and malicious harassment of a solicitor just trying to represent his client.
Well, I'm not sure what you're suggesting I can or should do. In terms of prosecution for any potential criminal offence, that wasn't a recommendation of the LEC, but in any event, that's a matter for the DPP. In terms of disciplinary sanctions against the police, that's a matter for the Police Commissioner. In terms of potential reform, criminal law reform, that's something that I'm looking at.
Attorney, one of the police officers retired with what's often described as a golden handshake, and the other one got promoted. Is that the consequences they're going to face for the deliberate, deceitful and malicious harassment of a solicitor trying to represent his client?
Well, in terms of their employment by the New South Wales Police Force, that's a matter you should ask the Police Commissioner about. Those disciplinary matters are matters that I can't be involved in or interfere with or oversee. But I've said what we're looking at in terms of criminal law reform, potentially.
Well, you said that whether or not charges are preferred against these 2, one former, one current police officer, is a matter for the DPP. Is that your position?
That's right.
Have you requested or have you done anything to get a brief of evidence before the DPP so as they can do their job?
That's not my role. The prosecution role in New South Wales is carried out by the DPP. You can, or Mr Kirkasharian can, or the solicitor in question can refer the matter to the DPP and ask them to consider charges.
Well, unless it comes from your office, the DPP says that they won't respond to those kinds of representations from private individuals.
Well, I don't think it should.
Attorney,
I don't think it should. Sorry, go on.
So that's the situation of the DPP. They won't respond to those private representations from individuals.
Well, I'm not sure that's correct, but in any event, I don't think I have a role in the prosecution of these police officers.
Well, the police aren't going to do anything. They've done non-reviewable action. You're not doing anything. So that means that the penalty for this deliberate, deceitful and malicious harassment of a solicitor is nothing. Is just nothing.
Well,
Are you really satisfied with that?
I can't, in my office, either as a matter of my role or a matter of my resources, provide any sort of brief of evidence to the DPP. In New South Wales, we have an independent prosecution service that makes these decisions about prosecutions, and it's really not appropriate for me, as the Attorney-General, to get involved in that. But what I can do is look at the potential for criminal law reform, not just in this case, but as a general proposition. What protections should lawyers be offered by the criminal law? And that's something that we're giving consideration to.
Well, Attorney, on the material in the LEC report, there seems to be a powerful potential prosecution for either contempt of court or perverting the course of justice. And on your evidence today, you're satisfied with just nothing being done about it, other than maybe potential future law reform.
I haven't indicated whether I'm satisfied or dissatisfied. What I've addressed is my role and my resources in the matter. With an independent prosecution service in New South Wales, it's a matter for the DPP to make those decisions. The magistrate that you advert to, I was unaware of those comments by the magistrate, but that magistrate can refer the matter to the DPP if he or she thinks appropriate. But I don't think it's appropriate for me to be involved in a day-to-day prosecution or asking the DPP to do it. That's a matter for the independent DPP.
But the DPP don't undertake the investigation and get the brief. Someone has to get the evidence to the DPP in the first place, Tony. Someone has to get the evidence to the DPP in the first place.
I'll take the point of order. This question has now been asked at least 3 times, and the attorney has responded to it. Like, you can't suck the lemon dry multiple times, David.
Well, that's not a point of order.
That's not a point.
Well, the point of order is that this witness has been asked and answered the question.
The member can ask the question as many times as he likes, and the minister cannot answer it as many times as he likes.
He has answered it. He has.
You've had a ruling, though, Trevor.
He has answered it.
That's not a point of order.
Attorney, the DPP can't rule on a brief of evidence if they never get one, and it's not their job to gather the evidence. Why won't you direct any part of your agency to at least pull together the evidence and present it to the DPP so they can do their job? Why won't you even do that?
Because that is not the role of either myself or my agency. We are not a shadow prosecution service that shadows or runs parallel brief of evidence gathering or collation for the DPP. That's just something we are not resourced to do, and something we don't have a role to do in an independent prosecution service system.
So the police get off scot-free. That's the outcome here. Well, the police get off scot-free for the deliberate, deceitful and malicious harassment of a solicitor just trying to go about and do his business and represent a client.
That's a matter for the DPP, that's a matter for the magistrate, that's a matter whether someone wants to bring charges privately, but it is not my role to run a shadow prosecution service.
Attorney, are you aware of the prosecution that was brought for the beating to death of an elderly, by all reports, kind, a generous Indigenous man in Summerhill in 2019? The prosecution that was brought for the murder of Paul Tavaladis?
I don't think I am.
Well, Attorney, 2 Irish nationals who have now left the country, Nathan Kelly and Christopher McLaughlin, were prosecuted for the alleged murder of Mr. Tavaladis and were both acquitted.
Is this at Bondi or Summerhill?
It was at Summerhill.
No, I don't recall that.
Well, Attorney, are you aware that indeed the New South Wales police officers who are in charge of the investigation sent a formal complaint to both the DPP and, as I understand it, your office about the conduct of the DPP in the prosecution of that case?
I have no recollection of that.
Well, Attorney, will you review your records and will you seek a response from the DPP from them about what, if any, action was undertaken as a result of the complaint that was lodged by the officers in charge of the Tavolaris case?
I don't have any recollection of that matter, so I can't say what I will or won't do, but now that you've raised it, I'll review the matter and then decide what appropriate action there is.
Will you ask the DPP what, if any, review action they took?
Well, I'll have to see what the matter is about first before I decide to do that.
Attorney, I assure you, before the end of the day, I will provide your office with a copy of the New South Wales Police complaint to assist you in doing that.
Thank you.
Can I just say, for the record, I cannot believe that such an injustice has happened to Mr. Tavolaris, and the behaviour, if the police complaint is even within the ballpark of truth, the behaviour of the prosecutor in that case is utterly, utterly inexplicable. And Mr. Tavolaris' family are owed a deep apology from the people of New South Wales. But I'll provide you with a copy of the police complaint this afternoon.
Thank you.
Mr. Thomas, the legal aid budget was reduced from $408 million last financial year to a budget this year of $405.7 million. Is that right?
I think you might be looking at our expenses last year and comparing it to the budget that's set for this year.
Indeed.
The budget for this year, the budget for this year is 404 as set through the budget process. It's actually increased since then. We've got some additional state and Commonwealth money, and it sits at about $414 million for the remainder of the year.
Do you know how much of that budget has been expended on deaths in custody matters?
I can provide that on notice. We do have a coronial team that does work around deaths in custody matters, and I can provide that on notice.
Would it be possible, Mr. Thompson, to get like the last 3 years so as we can get some kind of longitudinal review of it?
Yeah, I can provide you grants of legal aid, so any funding that we've provided to private solicitors, as well as the cost of that coronial team, and if you like, the nature, the volume of the work that they've undertaken.
Yep, thank you, Mr. Thomas. In terms of the income that's come from the interest earned on solicitors' trust accounts, what's the state of play in that, and what are the predictions going forward?
So the income that we received from the public purpose fund, I think as we mentioned in the estimates last year, that income had dropped significantly. Subsequent to that, there's been a lot of work done by legal aid, particularly because of the Department of Community and Justice and the New South Wales Treasury, to find some funding solutions to the hole that's created. Treasury has provided funding for the first half of this financial year to cover that gap. And subsequently, I might ask Ms. McKnight to explain the government's arrangements, but subsequently, the funds under investment are transitioning to be managed by New South Wales Treasury under TCorp. And TCorp are guaranteeing to provide us with the same flow of funding under those arrangements that we would have otherwise received by the PPF. So despite what happened last year in terms of the reduction of interest from the PPF, we haven't received a funding reduction because of that.
And is that commitment from TCorp an ongoing commitment over the next 3 to 5 year budget cycle?
Yes, that's my understanding.
Attorney, requests for redundancies in the Strategy, Policy and Commissioning Division of the Department of Communities and Justice were a request for expressions of interest for redundancies was made in February of this year, and I'm told that there are some 158 expressions of interest received. How many redundancies, first of all, is that right? And then secondly, how many redundancies have occurred in the Strategy, Policy and Commissioning Division of the department?
Unless Ms. Dealey can answer that question, I'll have to take it on notice.
Check my notes.
I can answer that.
Oh, thanks very much. Thanks very much, Ms Campbell.
Okay, 112 employees accepted voluntary redundancies and left DCJ as part of an upfront voluntary redundancy program. As a result of the upfront voluntary redundancy program, we were then able to assign 95% of eligible employees to roles in the new structure. Of the remaining unassigned employees, have secured temporary or ongoing employment.
Sorry, so 112 employees left, is that right?
That's right. It's part of the voluntary redundancy package.
And so that was that a headcount reduction of 112, a net headcount reduction, or full-time equivalent, however you want to call it?
Yeah, full-time equivalent.
Attorney, how can a unit as critical as the Strategy, Policy and Commissioning Division function with 112 less staff? Does that explain the delay after delay after delay that we've been discussing today?
I'm not sure what delay you're referring to. Are you referring to...
more than 2 years from the ICE inquiry, failing to respond to the raise the age, not responding to, critical review after review. We can revisit the delays if you want.
So in terms of criminal justice and legal reform, that's Mr McKnight's area of DCJ. Ms Campbell doesn't have responsibility for that area of DCJ, so they're quite separate issues.
All right. Well, Ms Campbell, what's been the impact of 112 less employees in the Strategy, Policy and Commissioning Division?
Look, I think there's been opportunities to consolidate a number of the functions across strategy, policy and commissioning. For example, we've consolidated positions so that we've got a dedicated domestic and family violence branch. Certainly, we're focused on the Premier's priorities. This division has lead responsibility for coordinating that across the department. And we've been able to look at synergies and bring together, different programs. So there's been some opportunities. Obviously, the reduction has an impact and we've had to reprioritise some of the work, but all the critical priorities that we're working on at the moment are continuing.
So, Attorney, the government says that it's a Premier's priority to deal with family violence and domestic violence, and your departmental response is to remove 112 positions from the division responsible for that very thing. How do those two facts sit? How on earth can you justify that?
Well, operational decisions about employment numbers aren't made by me. They're typically made by the Department Secretary. But you're presupposing that we can't do things better with a finite number of resources. You're presupposing that we can't utilise whatever workforce we have in a more efficient manner. And I think Ms Campbell has articulated how it is that consolidation and streamlining can occur so you can get superior results from a better organised workforce.
You must have heard a different answer than I heard, because I heard the phrase reprioritising, which means, if you look under the bureaucratic language, deprioritising for a whole lot of matters that you no longer have the staff for. And that's what's happened under your leadership, isn't it? 112 positions lost in this critical unit dealing with family violence and deprioritising of a bunch of their work.
Well, there's certainly been no deprioritising of tackling domestic and family violence or of the Premier's priorities, including a reduction in reoffending. The challenges in that have not been how many public servants we have working on the matter, but rather the increase in stats that we have from greater police activity.
Ms Campbell, what matters got reprioritised as a result of the 112 less staff that you have? And when I say reprioritised, given a priority that was lower than what it was before the staff reduction?
No, that's not true.
That answer is kind of like fish, but we'll leave it there.
Is that your answer, Ms Campbell?
I said that that's not the case. It hasn't been deprioritised.
No, so when you said earlier there had been matters had been reprioritised, Is your evidence now that you meant nothing had a lower priority as a result of 112 staff being cut from the division? Is that what your evidence is now? You didn't mean anything got a lower priority?
Sorry, I misheard your question. Yes, some things have been looked at. For example, a number of the positions were temporary positions as well. They were program funded and those programs have finished. So it's a lot more complex, but I'm certainly happy to take that on notice and come back with a clearer answer for you.
Thanks, Ms Campbell.
Government questions.
I'm very satisfied.
Satisfied?
Yeah, I am.
Okay, all right.
Sure, we can take out some of your time.
No.
But Natasha
not how it works.
Natasha has been chomping at the bit, so.
Okay, Natasha.
I'm okay.
You okay? All right.